Okay, it's 10 o'clock. Welcome, everyone. This is the State Building Co-Council Full Council meeting for Friday, April 25th, 2025. Can we please take roll?
Todd Byerther.
Here.
Jay Arnold.
Here.
Chell Anderson.
I think I printed an agenda. Can you?
I'm here.
We're doing roll call, please. Chell Anderson.
I'm here.
Justin Borgo. I believe he said he won't be available today. I don't see him in the room. All right, Tom Handy.
Here.
Thank you. Angela Haupt.
Here.
Roger Hariga.
I'm here.
Ty Menser.
Here.
Ben Omura.
Here.
Thank you. Pete Reiki.
Here.
Katie Sheehan. Not seeing them online today. Dan Young is also not available today. And with that, we have a quorum. And get into our ex officio members, Lauren Leftrop. Not seeing him online. Senator John Lubbock. Not seeing online. Representative Alex Rammel. Not seeing online. Representative Suzanne Schmidt. Not seeing with us today. Senator Shelley Short. Also not seeing her today. And Assistant Attorney General Dirk Merbeck-Tall.
I'm here, Dustin. Thanks all.
Thank you. And with that, we're sitting with the quorum and good to go.
Okay, thank you. And thanks everyone for your flexibility as we fought through the Zoom problem last week. So technically, this is meant to be our monthly meeting, but I think it's considered a special meeting under our rules. So
can I jump in for a second, Todd?
Sure, please.
Forgive me. I believe, correct me if I'm wrong, Dustin, that this is not a noted special meeting, but it's can you explain a little bit how that process worked so everybody's on the same page?
So when we encountered the issues with Zoom last week, we couldn't establish a quorum and the meeting wasn't available for online council members or the public online. And so in accordance with the OPMA, we adjourned the meeting to bring it to today. And as far as the kind of procedure, we're running with the agenda from last week as published. There is a slight modification to include minutes from last week. But other than that, this is kind of treated like a special meeting where we're not bringing up any specific extra stuff on the agenda, potentially in other business. But we adjourned per the OPMA to today.
Thank you for that. I was bringing it up for educational purposes, and that I think that's what we're achieving here. So say that one more time. Does that mean if you scroll down there, we do not have other business section on the agenda?
We have it on here, but we shouldn't be taking action on anything.
Got it.
Specifically there. We can
Okay.
talk about other business though.
Okay. Well, thank you. Completing agenda item 1, would anyone from the public like to be recognized? Go ahead, Patrick.
Yes, thank you. This is Patrick Hanks with the Building Industry Association of Washington.
Welcome, Deepa.
Thank you. This is Deepa Savarajan, Washington Local Policy Manager at Climate Solutions, giving public comment on item number 6.
6, thank you. Elizabeth.
Elizabeth Torsky with Cascade Natural Gas. Thank you.
Welcome. Larry.
Larry Andrews with Andrews Mechanical. Thank you.
Thank you. Jim.
Jim Dennison with Sierra Club, also giving public comment on item number 6.
Great. Thank you. Welcome. And then Greg.
Greg Johnson with Avista.
All right. Welcome, Greg. Okay. I think that's it. Moving on to agenda item 2, review and approve the agenda. Can we hear a motion to approve, please?
So moved.
Thank you, Shell.
Second, Angela.
Thank you, Angela. Any proposed edits or discussion? Go ahead, Tom.
Yeah, I noticed on the minutes there that we're missing several. According to the February 21st minutes, at that meeting, the minutes from January 24th and February 6th were not available. So they weren't voted on, so they are still out there in limbo. Also, we had a meeting on March 21st, and that's not included here either. So I think we've got at least 3 minutes that need to be added and approved at some point. So
Make sure to get those wrangled and bring them back. The March ones weren't quite ready, and we'll be sure to bring the other ones that you mentioned here at our next regular meeting.
okay, thank you.
Dustin, on that note, you know, this is a really nice feature on the website to be tracking all the meetings and have that history on there. And I see then, when do you post the minutes? After they're approved or as you're developing them?
Once a draft is ready, we are trying to get those posted, but then a final posting goes up on there with a different file name that doesn't include the term draft there. So
Got it. Okay.
that is the intent. If that is actually what's happening, we are missing some things on the website. We try to keep up with that as we can.
Okay. Well, no, but it's very helpful to have this page. So thank you. Okay, Roger.
Yeah, Todd, given the comment about being careful about what we introduce as other business, I did have an item that was scheduled last time, basically a modification to the open window for the proposal, the proposal window for the single exit multiplex housing tag. I didn't know if the intent was for that to be covered under agenda item number 10, which is updating the schedule for the 2024 cycle or not.
Yes, Roger, that was kind of where I was hoping to discuss that.
Okay.
Make any more modifications to that document.
All right, that's my only question. Thanks.
Okay, makes sense. Thank you, Roger. Okay, any other discussion? Go ahead, Tom.
Yeah, sorry, this is not exactly relevant to this, but Dustin, your audio is just a little light, and so.
Gotcha.
There's a way to fix that.
If I speak up a little bit, does that make it better?
A little bit.
Okay, I'll do my best to try to get it up, and when I get a moment, I'll see if I can get a room adjustment and see if it helps.
Thank you.
Okay. It's been moved and approved to adopt the agenda. All those in favor signify by saying aye.
Aye.
Any opposed? Okay, so approved. Agenda item 3 is to review and approve the 2 minutes posted there. We'll take a minute to scroll through them, but they are also posted. Okay, that's February 21st, correct? The second one, thank you.
Just a quick mic check in the room here. Any better? Okay.
Same.
I use my outdoor voice.
Move to approve both sets as presented.
Thank you, Tom.
Second.
Thank you, Jay. Any proposed edits? Dustin or Rosanna, could you maybe continue scrolling down just so we've seen the bottom? Thank you. Okay. All those in favor signify by saying aye.
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 And any opposed? Those minutes are approved. Agenda item 4, public comments for items not on the agenda. Would anyone like to address the council? Go ahead, Larry.
Yeah, I'm commenting about what's been happening on the commercial energy tag. And I don't think there's been a fair representation between what's happening there on the, what we're accepting and what we're not. I mean, they decided to remove the cementation blocks buildings that have foam in them. And but yet we can build a building with almost a complete glass wall, which is worse than what the cementation building is. And so basically you're just putting thousands of workers and a large part of Spokane industry out of business. And that's not right, because you're allowing the glass to be used, but yet you won't allow the blocks to be used that have a better R value than the glass. And it's become clear to me that we have multiple architects on the Energy Code Council, the Energy Code tag. And so the architects get what they want, but nobody else gets what we want. And even though we have walls that have greater R value than what the glass does. And to me, that's not right. I mean, if we're gonna make an assault on the CMU industry, we should make an assault on the glass industry just the same if we're trying to reduce energy, or at least give the CMU industry a way that they can still put out their product. And it is a good product for gyms and Safeways and Albertson buildings. And so I've become very, it's really hard if we're really trying to achieve the 70% reduction. To me, it's turned into a real joke. It's who has whose power to do what. It's not about what is the best for 70% reduction. And then I've asked the question several times before, and I haven't got an answer from you guys yet. And that's just like saying, well, we don't give a shit. And so if you have a 70% reduction in energy use, now they built homes, lots of them, with electric heat and heat pumps. So we're going to demand that house that was built in 2006 to have a 70% reduction from where they're at today. And I don't think it can be achieved. In fact, I spent a bunch of money this week to get the results, and I'm going to publish them. And I don't think you can get to where you're asking for what the legislature asked. I think we had people that wanted something, but a lot of times it's not achievable without the cost of $1 million or more.
Hey,
And
Larry, sorry to interrupt you. So you're talking about a specific petition that's up right now that potentially is at risk of, under our new rules, not being recommended by the tag, therefore that petition would die. Is that correct?
well, it was recommended by, we had votes, but we didn't have the votes to pass. But we had multiple architects on the tag to do that. Okay.
Yeah.
And in the Seattle area, they have a huge presence on the tag. Okay.
Okay.
And what's good for the goose should be good for the gander. Okay.
Larry.
And it's not.
No, thank you. And noted here, I obviously don't want to deliberate it here, but thank you for noting that. And it's relevant to bring it up just because it's a new process for us this year in the denial process. And I think what you're referring to are mass walls, and I'm not familiar with it, but thank you for noting it to the council.
The mass walls.
This came up last time too. So, okay. Thank you, Larry.
Yep. Okay. Thank you.
Okay. Any other, anyone else like to address the council? Okay. If not, we'll move into agenda item 5, which are the committee reports. We can go in order here. Executive committee was, to my memory, pretty short last, again, we've staggered these in between. So technically it was 3 weeks ago now, but we mean for them to be every 2 weeks. And one of our main goals is to approve this agenda and talk about it up front and take care of whatever we can to streamline our full council meetings. In addition, if you remember, we do have the ability on the executive committee to approve tag seats. I can't remember. I think we did, but we're also bringing that forward today. So that will be something we'll review today as a full council. Anyone have a better memory than I do on the executive committee? And I'm leaving out anything? Okay. If not, we'll move into the MVPE. Ben, are you willing to give us an update on that since you led that?
Sure. Thanks, Todd. And yeah, as you mentioned, I was elected the ad hoc chairperson for the meeting, as we currently have a vacancy for that position. The agenda was focused on reviewing the MVP tag reports regarding the UPC plumbing code significant changes and existing state amendment review. So that's what you see there and are part of the meeting packet for today's council meeting. So I believe the action we would have is to review that in more detail as needed, and then potentially take council action on opening up the proposal window for the plumbing code.
Perfect. Thank you, Ben. BFRW, Roger, please.
Yes, we, BFRW met, what was it, April 11th? We had discussions on, basically there are 4 proposals that are currently being discussed by the BFRW. The stairway pressurization and static damper proposals are basically almost complete and ready to get moved on. I think one of them had one more round of a few comments. The EV charging proposal and the embodied carbon proposal, what the BFRW committee is in the process of doing is basically taking over document management, where we are going to publish on the website the most current version. The EV charging proposal is one that that was introduced basically at that meeting, but it incorporates basically all of the information from the 3 potential proposals. So it currently is called the combined version. And then the embodied carbon proposal, the proponent has gone through some additional work with stakeholders, and it is our intent to publish that and get it on the website post haste here, so that will be the document that we move forward with. So basically the BFRW is working on taking over the document management, so we know we have one version of those 2 proposals there that we are working on. And Corey, yeah, that's fine. We are working on getting those. I know that they are not yet up on the website, if that's your question, Corey. So that's the end of my report, Todd, unless there's something else that I
Nope.
missed.
Well, maybe let's take a comment from Corey or a question here, and then come back to what the schedule is for the 9th. Corey, go ahead.
Oh yeah, thanks. Sorry to interrupt. I just wanted to know if there was a projected date that draft would be available, because I heard last meeting that we were going to be discussing it potentially on May 9th, and I just wanted to be able to provide the comment necessary. So that's what I'm here for.
Okay, thank you. Dustin, go ahead.
So on addressing Corey's comment, we can get that up here in the early next week and get that on. But I wanted to rewind also back to the MVPE report. That committee did also recommend the reports to the council as approved by that committee. And I had intended to review those reports in this portion of the meeting to discuss and open the window here. But if we want to open the window in the schedule update, I have no problem with that. But I thought that we were going to review UPC reports in this portion of the meeting.
I see. I think either way, I kind of interpreted like Ben did, that we,
Okay.
can we include that in can you scroll down, please? I mean, it's the will of the council here, what you would want to do, but is it appropriate that it's in the, oh, I see. What would the council like to do?
Dig into it.
Go ahead, Ben.
Yeah, I guess, Todd, if appropriate, I would definitely make a motion to recommend that the council accept the reports from the MVP tag and open up the proposal window for the 2024 UPC code change proposal window.
Okay.
I'll second that.
Okay, that was Katie, second. Thank you. Okay, so in one motion, we've moved in and seconded to accept the UPC reports, and likewise, did you give the dates on the proposal window?
2 moments. It was going to be from starting today, and have to get into a different document here that I didn't have open yet.
I think that's where I was thinking we would do it in the schedule, but that's okay. We can do it now.
Gotcha.
In 1 second, Patrick, let's get the dates out there and then we can take some comments here.
All right. From today to June 23rd.
Okay, so April 25th to June 23rd. Ben, is that acceptable in your motion?
Yeah, so I believe Dustin is basing that on the standard 60-day minimum. So yeah, I think that's what's been discussed. And then the intention of the motion would be to review the applicable reports. And if anyone had any questions, we could look at those and review them. They are fairly long documents, so I don't believe it's worth the council's time to go page by page, and hope that everyone had a chance to review those as they were part of the meeting documents for some time.
Yep. Agreed, Ben. Thank you. I think that was the intent, is that we did such a thorough job in the MVP that, but if any council member would like to raise a concern on that. Real quickly, Katie, do you accept that second on the dates? Thank you. I saw you nod, so I'll take that as affirmative.
Yes, it's affirmative.
Thank you. Okay, Patrick, go ahead.
Yes, thank you. I had a meeting conflict with yesterday's tag meeting, so I was just wondering if the reports, I know those were on the agenda, if there's anything changed, or if the tag was what happened, and if the reports on today's agenda were reflecting any changes from then. Thank you.
Patrick, we're specifically referring to the UPC reports right now. Or are you referring to something else?
Todd, I can answer that.
Oh, thank you, Ben. Yeah.
Yeah. So, and Patrick's correct. We had we had scheduled a tag meeting for the MVP tag for yesterday, and the intent of that meeting was to review the items that are in this report that we're going to look at that were flagged for potential code change proposal, to just talk through those in a bit more detail, and then also assign it to any tag members or members of the public that would be willing to help start creating those proposals once the window would be opened up. And there was one item that the tag did change their recommendation on that I can review once we start kind of going through the reports.
We can do that. I mean, it would be without action by the MVP, obviously.
Yeah,
but
correct.
I guess I need a little guidance if there's a proposed change in there from the tag. If I suppose the council could accept them, and with that proposed modification, I guess I need a little guidance there. But if if you want to just jump right into it, we could do that right here. If that's your desire.
Yeah, yeah. So Dustin or others, yeah, let's kind of open up those reports, I would recommend, and we can kind of provide some guidance on what these are showing and what the tag and the committee had reviewed.
Okay. And just for everyone's, my understanding of this, and please help me if I'm incorrect here, the formal action we're taking is to accept them. We're accepting the reports as a full council. And that's, a necessary step or best practice before we open up the window for petitions. So that's what we're doing here today. I don't know if there's anything that prevents us from modifying this and accepting it as a council, but go ahead, Ben.
So this report is a review of the model code changes in the 2024 UPC, and similar to how we reviewed the mechanical and fuel gas code, the tag provided recommendations based on the initial staff review, if these model code changes should be accepted, or if there were potential conflicts with existing legislative rules or other regulations that would then require some sort of code change proposal to provide a state amendment to align those with those requirements. And so you see here, as you go through, we have a couple columns indicating that the tag had accepted the change in the second to the right post column, and then if there are any notes for either additional review, or you see here for section 104.4.5 that there's a potential code change flagged. And then we identified in this one that Steve Hart would be someone that would be interested in reviewing that item.
Okay.
And so that's just providing a flag that even though the tag recommended accepting the model code change, there may need to be some code change proposal to bring the model code language into alignment.
Okay, so we can accept this as a council, and now it's flagged for the petition process. Okay. Is there any other action you would like us to take on that?
No, I think that's it. Obviously, the way that the tag had reviewed this is that unless there were editorial changes or things that were in direct conflict with state amendments or regulations, that the model code changes would be accepted in general. So there weren't any new language or other modifications that were proposed as part of this initial tag review.
Okay. But this amended report is what we are accepting today.
Correct.
Okay. Okay. Anything else, Ben, you'd like to show us that in this report?
No, that's it. And then, yeah, if we go over to the state amendment review, it was a similar type of document. And Roger has his hand up.
Yeah, Ben, if you can clarify for me, and I think I know the answer to this, but when you say the model code, it is this is the one code that is not an I code. Is that correct?
That's correct.
Okay, so it is a uniform plumbing code, and that is just, I just wanted to confirm. I know as we've gone through all these different codes, this was the only one that was not an I code. So we're still basing it on a published model code. And other than that, it's the same as all the other code adoption cycle, correct?
Yes.
Correct. Yep. The state adopts the Uniform Plumbing Code, the UPC, and publishes state amendment insert pages.
Okay, thank you.
All right, and in here, this is the existing amendment review. So identifying sections that have state amendment language that are published for them. And the tag reviewed this in very much the same way, reviewing the existing state amendments and noting where there are instances where perhaps the existing state amendment language may need to get modified due to the model code change. And in some cases where the model code change would be either adding in new information into a certain section that would need to get modified, or in some cases where the model code was using similar language that the state amendment had. So the state amendment could be reduced in scope based on already having that covered in the model code.
Okay. Any questions? Go ahead, Patrick.
Yeah, Ben, you said that there was one item that the tag changed its recommendation on. Can you say what item that was?
Sure. You I thought I had flagged it, and I don't see Brandon, the staff member who was on with us last time during the tag meeting.
Ben, would you like me to go back to the,
Oh, there's Brandon.
would you like me to go back to the model code change?
Yeah, do you have it flagged in there, Brandon? I believe we had discussed it.
I believe it was about the backflow prevention devices after speaking with the Department of Health.
Correct. And yes, yeah, I believe it was, yeah, if you go back to the significant changes document, and then this would be in section 603.2, I believe. And I believe, once we get to that, oh, yep, a little bit further. Great. And then, yeah, the change was that as we're reviewing, there are several backflow preventer changes in the model code, and one of the changes was to the table we're looking at here to include additional information for the carbonated beverage dispensers. And one of the things that the tag members, and then we had a person from the Department of Health join as well, is that the ASCC 1022 backflow preventer noted for these in the table would not be allowable under current state regulations. So that, and the initial tag recommendation was to accept this table with the changes indicated in the model code. So the change that the tag was recommending would be to flag this for code change proposal.
Okay, that's helpful.
But otherwise, the tag recommendations remain the same for the rest of this report, as well as the significant changes document, or the state amendment document, excuse me.
Okay. Okay, thank you. Larry, go ahead.
Could we roll back to where it talks about the shower requirements? Because Mr. President Trump rolled back the shower requirements.
Larry, are you implying that that
Yeah,
change should be
yeah,
proposed here, or just be proposed as a, when we open the window up as a petition?
well, what I'm saying is that the proposal isn't with federal law now. And so people that want a power shower in their house, we're not able to get that under present requirements, even though most jurisdictions allowed it, but the state said you shouldn't. But I think there's a proposal in here that we need to remove or adjust because the requirement for showers now has been removed in the federal requirement.
Okay, but that could be addressed by a petition once we open the window up. Correct.
Sure.
Okay.
Thanks, Todd.
But thanks for flagging it. Yeah, thanks. Shell, is that what you were going to say also? So,
Yeah, I was going to point out the difference between a law and an executive order.
oh,
They're
okay.
quite different.
Okay. Just to be clear, today what we're doing is we're accepting these two reports so that we can move forward and receive petitions that are responding to them. And so as long as the council understands what we've done today here is we've received the recommendation from the TAG that then was the recommendation from the MVPE with additional recommendation on these items that we discussed today. So go ahead, Roger.
Yeah, so these are recommendations from the initial tag work and staff work. But once the window is open, any proposals for any code changes can be submitted by anyone.
Correct, right. So it's always good to say that out loud, what we're doing and making sure we're all on the same page, but that's correct. Okay. Any other discussion? I guess it's been moved and seconded, right, to accept the reports as modified and reviewed on the screen. Let's try a voice vote. All those in favor signify by saying aye.
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 Any opposed? Okay. Now, when I restated the motion here, that also included opening the window for the dates certain that were described. Did anyone not understand it in their vote? We'll take a separate vote if needed, but it was in the original motion, so. Okay, I'll accept that as that was understood. Okay, go ahead, Patrick.
Can you just restate what the dates for the submittal window was, please?
April 25th through June 23rd.
Thank you.
You're welcome.
And that we'll review the schedule in a future item here today. Okay, thank you for that, Ben. Bouncing back to the BRFW. Roger, is anything else you want to say, setting up our May 9th meeting, just kind of a preview, and then it'll be posted in the agenda?
Yes, and I think I would, so I believe that the four proposals, two are very, very close to being ready for recommendation for approval from BRFW. The other two, now I don't have them in front of me, the EV charging and the embodied carbon will continue to work on with the intent of that being resolved by the June BFRW meeting so that it can be basically final approval from the council will occur at the June council meeting. So just kind of stating our intended schedule for May and June.
And so to be clear, what we've established is this next meeting, especially on those two proposals, EV and embodied carbon, we're going to review actual code language and continue to work.
Yes.
And
Yeah.
take input.
On the BFRW proposals that are going to get published on the website here post haste.
Correct. Thank you. Okay. No other questions or comments on that? We'll move on to Legislative Committee with Tom, please.
Yeah, most of the bills that we had been concerned with anyway have kind of dropped off into the dead zone this year. So in some ways that's good. We had worked with a few along the way and had some changes, with regard to, how the building council works and timing and those types of things. And even though those died, I think several of them may reemerge next year. So we'll keep an eye on that. Our schedule, we're going to continue meeting weekly until the session is ultimately over, whether it's scheduled or regular, or, any additional work that they come back into session for. And then we will go to a less frequent meeting schedule, probably every other month, depending on what's going on, but always keep our ears to the ground, as to what might be coming up next year and revisiting maybe some of these that'll try again. So that's pretty much it.
Yep. And we look forward to welcoming our ex officio members back when they can get their head above water. Okay, thank you, Tom. Okay, if there are no other comments or questions on agenda item 5, we'll close the committee reports and move into agenda item 6, which is our I-2066 petitions. Maybe I'll start to set this up, or Dustin, and then do you want to, Dustin and Derek, perhaps want to support this? We put this on the agenda item to give an update on the status of the council action on this, specifically related to our motion and action on November 22nd, I believe. I don't know, Dustin, if you happen to have that, it might be beneficial. We might want to reference that in our discussion here. Specifically, though, if you remember, that action directed the tags on the 2024 process to continue. That window was open and closed on both the commercial and residential, and asked for petitions or it was inclusive of having 2024 or I-2066 considerations. The council took action specifically to prepare if there was potential 2021 amendments needed, and in doing so, open a window that is now closed as of, I believe, April 7th. So that was the intent to acknowledge that window closed. There were petitions received, and specifically then and that is in the agenda packet, a list of those. So I want to thank everyone who submitted those petitions. And then the question before the council is just to document, let me say, to document that those have been received and make sure that in our notes that this process, that's acknowledged and we can reference back to that. Okay, and just to be clear, this is a motion and as a PDF. This is, if you remember back to November 22nd, I believe this motion was originally proposed by Representative Rammel, and there was discussion and amendments to it. So I assume this is the amended motion. Is that correct, Dustin?
Yes.
Okay. In that, if you kind of scroll down there, you can see that right there in the middle there. To that end, we direct the energy code tag to continue to advance the 2024 energy codes. That is moving forward, and to bring forward cycle recommendations to update the 2021 energy codes if needed. So here we are, and we received those petitions. And at this point, I'll leave it to the council or to Derek to give any updates on the current status. But at this point, my recommendation is that we are not directing the tags or a tag on the 2021 process. We are prepared, depending on the status of I-2066.
Yeah, Todd, do you mind if I jump in and say something?
Please do. Thank you.
Yeah, you bet. I think council members received a letter from, excuse me, from the Sierra Club that was staff counsel at the Sierra Club sent yesterday, which made some statements and provided some analysis with regard to the current whether I-2066 is currently good law and what impact, if any, the Superior Court's oral decision striking down I-2066 on a constitutional basis, what effect that has. And so let me, if I can, I just want to, excuse me, uncharacteristically have a frog in my throat. Excuse me, not a real frog, I promise. Let's take a step back and let folks know, because this is just a little bit of an update. So as we all know, this motion that we see on the screen was passed by the council following 2066 going into effect. And Initiative 2066 imposed new requirements on the state energy code. And so under this motion, the energy tags were directed to move forward with respect to the 2024 code. And as Todd just indicated, if needed, the 2066 code. At the same time, or shortly thereafter, a constitutional challenge was filed, County Superior Court, alleging that the 2066 was unconstitutional. The State Building Code Council is not a party to that case, hasn't expressed any opinion on the constitutionality of 2066. So we've been monitoring it, obviously, because it impacts the work of the council. I know, by the way, I know there's several people here who have indicated they want to speak to this, and so I encourage anybody to fill in any gaps that I offer or push back on anything that I say if I get it wrong. But I meant to look up this precise date. Maybe about a month ago, and someone will correct me if I'm wrong, the King County Superior Court heard the arguments on the constitutionality of 2066 and ruled from the bench that 2066 is unconstitutional. We anticipated at the time, I think we talked about it, that a written order would issue shortly thereafter, and at least as of this morning, it hasn't. So the questions have arisen. I think maybe some of you have been asking, council members. I know members of the public have been asking, well, should the council be moving forward with complying with 2066 because a written order hasn't been issued? What is the effect, if any, of that oral ruling? Should we kind of stand by and wait to see what happens? It's not uncommon for courts to take a little bit of time to try to be deliberative in issuing a written order. My understanding of the law, and this is contrary, I think, to what you might have read in the Sierra Club's letter, and probably what we'll be hearing from folks. But my reading of the law is that a judgment on the merits of a case, which is what the judge has issued or will be issuing in writing, hopefully soon, goes into effect at the time of the written judgment. It is binding on the parties to the action when it's issued in writing. Now, that's different than an order, and that's what the Sierra Club letter has pointed to is contempt orders, for example, can go into effect right away. And that makes sense, right? If you're in court, the judge says you're in contempt, that has immediate effect. But, I think case law is pretty clear. If the judge say, here's my decision on this, I'm going to reduce that final decision in a case to writing. It's really that when it's reduced to writing is when it goes into effect. Why is that important? Well, that's the time that, the action or the decision could be reconsidered following that formal entry of the order, the final order disposing of the case. It's when an appeal can be taken. And so sort of pragmatically, we wait until we see a written order because a judge theoretically could change their mind in between the time when they make their oral ruling and when they file a written decision. The terms of that order, the wording of that order could matter. And of course, there could subsequently, if there's an appeal, there could subsequently be a stay of that order or that final decision, rather, which in turn could affect the rights of the parties. So we've been kind of eagerly waiting to see what the final decision looks like there. But I want to be clear about something. I want everybody to hear me say this. We have no information or reason to believe that the judge in this case is going to reach a different decision when she files a written judgment. I've carefully read the transcript of the proceeding, and I didn't see anything in it that suggested to me that there could be a change in opinion. So I think for all, again, sort of pragmatically, the council, and I think members of the public want to assume that 2066 is going to be going forward, not good law, until the Court of Appeals, Supreme Court potentially reverses it, or whatever decision happens. Again, SBCC isn't a party to the action and don't have any opinion on it. So that's my assessment of where we're at on this. We've, if asked, and maybe Roger's about to ask, hey, what do we do on this? I think that's a business decision, ultimately up to the council as to what steps you would want to take with respect to the 2021 code. There might be good reasons why you would want to continue analyzing the implications of 2066 on the 2021 code. That I would leave that to you as to whether or not that's a good policy decision. But at this stage, I think it's really about policy. It's not about legal risk, because as I said, for all intents and purposes, 2066 has been determined to be unconstitutional, and we'll see what the appellate process looks like as we move forward. I'm seeing hands go up, so I hope that's not because I was unclear in anything I said.
Oh, that's helpful, Derek. Thanks. Roger, why don't you go ahead?
Well, Dirk, I am going to ask you for clarification. You, at least twice, you referred to it as good law.
Did I say that? Did I say 2066 is good law?
No, well, and that's where I think I had interpreted what you were trying to say both times as not saying that whether it's good law or bad law, but whether it is in effect.
Yeah, what we see in the case, so I was being a little imprecise there. So let me be clear. What you see in the case law, the word they use is binding decision, right? Okay. So 2066 obviously impacted and directly impacted the work of the council. And technically speaking, as I stated, the judge's ruling declaring the law unconstitutional isn't binding until that final written order is issued. But again, just for real, right? The judge is not going to issue an order. It's very, very unlikely that the judge will issue an order that contravenes or is inconsistent with what she stated in her carefully reasoned comments from the bench.
Okay. Thank you. Angela, please.
Yeah, I had a question about, so how long does it usually take them to do their written portion of it? And if I'm understanding correctly, after that is published, that is when we will find out if there is an appeal,
right?
Correct?
That's right. So I can't speak to, on average, how long. There is a state statute and constitutional provision that requires that it has to be done within a certain amount of months. I can't remember the exact number off the top of my head. And again, folks who are actually involved in that litigation might have some insight into actually the process. My understanding, and maybe I should have said this from the beginning. I see Deepa's hand is up. She might know. My understanding is that proposed orders have been presented to the judge, and the parties are currently waiting for the judge to issue a written decision. And from my reading of the comments, the transcribed comments when she issued her oral decision, I think she wants to be very careful in what she says and thorough in what she says. So I anticipate that that's what's going on, but that's just me guessing. The decision could come down today, could come down Monday, sometime next week. I'm just guessing. But to answer your second question, Angela, yes, that's when an appeal would be taken, is following the entry of the final order in the case.
Okay. Tom, why don't you go ahead? We are accepting comments and questions from anyone, not just council members here. So Tom, go ahead.
Yeah, I was just confirming, and maybe you did say that a written, it will be coming, right? I mean, there's no option in providing that written.
Yeah, the judge, unless there's some intervening the action in that case, there will be a written order. The judge has requested it. The draft orders, proposed orders have been presented, and the judge, as I understand it, is currently considering them.
Okay, thank you. Deepa, please.
Yeah, thank you for the opportunity to speak. Deepa Sivarajan with Climate Solutions. We are one of the plaintiffs in the case. Firstly, just wanted to mention, I don't know the timing either, but my understanding is that Judge Woodland has been on leave, and that is part of what's affecting the timing of the written order. Otherwise, my understanding is similar to Derek's. But I did want to, say that we are in support of Chair Bayreuther's motion on this related to 2066, and I would like to also read from a letter from Pacifica Law that was sent to the council yesterday, but I understand it may not have yet been distributed to all council members. Just want to note here that Pacifica represented the plaintiffs in this case and also was directed by Judge Woodland to help in writing the written order. So even though that order isn't out yet, that's the perspective from which Pacifica Law is writing. So here I will read from the letter. Dear Chair Bayreuther and members of the State Building Code Council, I write on behalf of a broad plaintiff coalition of local governments, business interests, and public interest advocates that have challenged the constitutionality of Initiative Measure 2066 in Climate Solutions et al. Versus State of Washington. As you are aware, on March 21st, 2025, King County Superior Court Judge Sandra Woodland held a hearing in Climate Solutions to determine whether Initiative 2066 violates the Washington State Constitution. Following comprehensive summary judgment briefing and oral argument, Judge Woodland granted plaintiff's motion for summary judgment and declared unequivocally that, quote, Initiative 2066 is unconstitutional, unquote. A copy of the transcript of Judge Woodland's oral ruling is enclosed as Exhibit A. Accordingly, Initiative 2066 is not the law of Washington State and may not be implemented or enforced at this time. We understand that some members of the council have expressed uncertainty as to whether Initiative 2066 has been struck down absent a written order from the court. To be clear, a court of competent jurisdiction in this state has ruled that Initiative 2066 is unconstitutional and invalid. Courts expect their rulings, oral or written, to be respected and followed, including in the interim period before a written order is entered. As the Washington State Supreme Court stated in State versus Sims 2019, quote, oral orders are effective and enforceable even if they can be modified prior to being reduced to writing, unquote. Quote, again, the court system routinely relies on compliance with oral rulings to maintain the orderly and efficient administration of justice, unquote. Pending the issuance of the written order, we encourage the council to act in accordance with the court's clearly stated oral decision. At a minimum, the court should defer any decisions that the council believes depend on a written order until such order is issued. Sincerely, Kai A. Smith, attorney, Pacifica Law Group. So one last thing I'll just mention is, I know that it has been this council's practice to, treat whatever is currently law as the indication of how to proceed rather than something that might be pending appeal that has come up in various times when the State Building Code Council themselves have been sued and have not acted upon the speculation of a future decision, such as a future appeal or a future stay. Finally, I'll just mention as a member of both the commercial and residential tags, the primary and the commercial and primary on the residential and alternate on the commercial, that we have so much work ahead of us in the next few months, and we have a timeline within which to get through the 2024 proposals that I really encourage the council not to add to that burden with 2021 code proposals that do not have a timeline to be reviewed and accepted. Thank you.
Okay, thank you, Deepa. We're going to keep going through comment here, but I want to bring focus to what we're talking about today to the council. And I'm going to back up a little bit. We are discussing our process today to move forward on 2024 and potentially 2021. As everyone knows, our RCWs 1927-032 establish how we amend our estate building code. We are in our 3-year process. That's option 1. That's mandated that we do that. So we are in our 2024 process, and the motion and the action on November 22nd addressed how we're going to consider potential amendments and petitions for the I-2066. The second, if we were to go down a path of 2021, it would require that the council establishes that we're going into an emergency amendment process. That can be done because a change in federal or state law, that's what we're discussing here, that would trigger the council to establish emergency basis to go into that process. Or it can be an external petition, as we've just experienced recently in the last month or two. The council was petitioned and the council did not establish an emergency basis to go into that process. So the point today was to raise this again, document that we acknowledge we closed the 2021 petition window that we opened, and establish where we are and whether or not the council needs to take action. So please, let's keep talking about the context of this and what the council needs to do right now on both the 2024 and 2021 process. So, okay, Jim, please.
Thank you. I'm Jim Dennison, a staff attorney for Sierra Club. I submitted the comment letter that Dirk described, and I will just briefly clarify a point or two from that for the commission's benefit. As to the legal effect of an oral order, as indicated in the comment letter, every legal authority that I'm aware of in Washington indicates that oral orders are binding in the same way that legal orders would, or written orders would be. Dirk correctly pointed out that one of the cases cited in our comment letter, State versus Sims, a case from the Washington Supreme Court, concerned a contempt order. But in that opinion, the court stated there's no reason why contempt orders should be treated differently from other orders. Parties are generally required to follow a trial court's oral rulings. And that's consistent with all the legal authority that I'm familiar with, including several cases cited in State against Sims, as well as some other Washington Court of Appeals cases cited in our letter. I have not seen anything indicating that oral order needs to be reduced to writing to have effect. But I think more broadly, perhaps the kind of legal particulars are moot because I think, as Dirk indicated, there's no reason to believe that there would be any difference or any reason that, for all intents and purposes, the order invalidating Initiative 2066 is not final and effective. So that leaves the council to consider how most effectively to proceed and use limited resources. As indicated in our letter, and as Deepa mentioned, the most prudent course here is to focus those limited resources on developing the 2024 codes rather than speculating about any potential developments that might happen on the lawsuit as it relates to the effectiveness of 2066. So thank you, and happy to answer any questions.
Okay. Thank you, Jim. Let's go to Greg.
Yeah, I just wanted to highlight there's an overlap between I-2066 and EPCA. I know you guys are focused on the EPCA, but throughout the I-2066 review, many folks identified some EPCA violations that were never properly remedied. So regardless of what happens with I-2066, we still need to comply with EPCA. And I won't speak for all the proposals. I haven't evaluated all of them. But as for my proposals, most of my focus was just pulling together changes that the tags already agreed upon for the 2024 codes and just bring them into the 2021. So, and those are items that are impacted both by I-2066 and EPCA. So for the majority of mine proposals, I anticipate much less debate since there's already been a high degree of agreement. So regardless of what happens to I-2066, I would encourage the council not to put the whole thing on hold, but maybe move forward since we do have some gaps on EPCA still in our current code.
Okay, thank you, Greg. Go ahead, Patrick.
Yes, thank you. This is Patrick Hanks with the Building Industry Association of Washington. I I agree with Derek that until the court order comes through, technically I-2066 is still in effect, but it is anticipated that that court order will change that. However, I can say as part of as being part of the organization that's party to that lawsuit, that there are plans to appeal that to the state Supreme Court. So the council is in a difficult situation in which, while that court order may go into effect, it's quite possible by the end of the year that you could have that reversed, and then 2066 will be back into effect. So I think whatever action the council takes today, it's important to accept these petitions as valid. They were submitted as part of the rulemaking process you started when 2066 was in effect. And the window was largely within that. So accept them as valid. And then so that way you still have them as an option in case that the Supreme Court rules differently, so that you don't have to restart the rulemaking process, open another petition window, which will greatly slow the compliance time and really make things even more difficult, because at that point, the 2024 code will likely be approved. And so you'll need to get changes to the 2021 code done very quickly before the 24 code goes into effect. Thank you.
Thank you, Patrick. And just to clarify, to Patrick's point, that was part of the intent of putting the agenda today, and to publish those petitions. So they are now public record and available. Thank you. Okay, Johnny.
I won't take up too much of your time. I'm going to largely be echoing what Jim and Deepa were saying. I don't think that we need to be moving forward with these 2066 petitions, given that the judge had the bench ruling, and we have a lot of work ahead of us in a pretty short time on the commercial residential tag in order to be able to complete the work by the end of the year for the 2024 code. So I think we should be focusing on what we do have a statutory deadline for. And should there be a series of events that occur that require us to be doing 2066 rulemaking, I think that could occur at a future point. But yeah, I think we should keep our eye on the rules that we know we need to comply by, which is end of the year. We need to do a lot of work on our tags. Thanks.
Thank you, Johnny. Larry, please.
I've got a question for Derek. I thought that state laws had to be in courts in Thurston County and not in King County, the county that is the far left county that had the most votes against 2066. And so I don't understand how a state law could be heard in a court in King County like that. I mean, you could take a county down in the Palouse area and do this, but I always thought you had to have in the Thurston County that those laws had to be heard by the court in Thurston County. Can you talk towards that, Derek?
I can speak a little bit about that. I am not a litigator in the sense that I appear in courts all over the state, and so I would defer to smarter people than me on the civil rules and venue rules and the like. You might be thinking, and I'm not going to speak as to whether or not one county is better than other counties for bringing actions. But I will say that there are state laws that require certain types of actions to be brought in Thurston County, rules challenges, for example, and this wasn't that. It's not uncommon for individuals who are challenging state laws, suing the state of Washington, to bring those actions in wherever their home district is. So I think that's me saying, Larry, I don't think it's right to say that this type of action needs to be brought in Thurston County, although there could be specific issues case by case as to whether or not venue is proper in those specific cases.
Okay, thank you.
Thanks, Derek.
You're welcome.
Thanks.
Thank you. Okay, Katie.
Thanks. So I guess I have a question and then maybe some follow-up.
if this court ruling hadn't come down, then we would be voting to accept these petitions and send them back to the special tag. Is that correct?
So I'll weigh in here. You know, I expressed the two pathways, the mandated 3-year cycle, that's the emergency cycle. There was some discussion whether this was a legislative mandate also, right? If you remember when we took that action. Now, that said, there is a question, if we were to do that, who does this go to? Does it go to the 2024 tags? And I asked the question, is that what they signed up for? Does it go, or does it go to a standing committee? Because that's also an option. So it's not, we didn't define that in the action in November. That is where the question we would have on the table right now if we were going to move forward on this for the 2021.
So we would have been accepting the petitions and then trying to figure out where to send it for further.
Right. Maybe I'll go further, because this isn't part of the 3-year process where we lay out the process for the petitions, and it's either best practice or, you know, it's within our policies and so forth to send them straight to the tag. So yes, that is what we're discussing today, what we could or would do, or simply say we've received these petitions, we are ready, depending on you know, on how context changes.
And then in the alternative, we could set them aside because of this court ruling.
Right. We've received them. We are ready if further action is needed. We've published them, and this conversation is documented. We've taken public input on the process.
Got it. Okay, thank you.
Go ahead, Ty.
Thank you. I hope this isn't duplicative of Katie's question, but I'm still confused. Like, so if 2066, if there had been no court case in it, and it's still good law because the written ruling hasn't come out, or it's going to be good law because it's going to get overturned. But if we're still dealing with that, wasn't there another question like up front for the council about whether or not it was purely prospective versus having to go back? And I know there's been public comment about that. I think Chell even early on made some comments about that. And have we resolved? I mean, I thought that we wanted to be, in my view, we were being abundantly cautious and saying, maybe we have to go back. So let's get sort of that process rolling. But to me, it hadn't been decided or debated or determined that that was the legal effect of 2066 as passed. So when does that question get addressed by the council, or has it and I missed it somehow?
Do you mind if I weigh in a little bit on that?
Please do.
Yeah. No, you haven't missed anything, Ty. As I understand it, and Todd, you correct me if I'm wrong, the strategy here was, boy, we've got this new law, it's passed. Let's start to get some input from stakeholders regarding what compliance with that law could look like if it does apply. But questions regarding actually what the law requires, including questions with respect to its potential retroactive effect, what it means specifically with respect to the codes, what some of the terms mean in it. Nobody has authoritatively weighed in on that. Certainly no judge has. And I think we anticipated that those would be conversations and analyses that would surface as part of the if we got there, the review of the 2021 code. Certainly we would invite, stakeholders, members of the public to weigh in and give us their opinions on it to help educate the council as we go forward. There's not a roadmap for this, so the knowing more is helpful. But that's the long answer to the question. No, there hasn't been any specific analysis that's done or opinions rendered on those questions, Ty.
So procedurally, it would be okay. Again, this is assuming 2066 still good law.
Understood.
It would be okay to send it through this next part in the process, even if I wasn't sure that it is retrospective, or I've still had questions or concerns about that? Or is this the gate where we need to sort of decide that before we take this next step in we would take the next step in the process?
I think this is so my view, and Todd, if I'm speaking out of turn, let me know. But my view is sort of an iterative process. Nobody is asking the council at this time, and the council hasn't been directed to take immediate action here on with respect to the 2021 codes. So my view is you wouldn't need to make any decisions today on whether you believe that 2066 applies. If it hadn't, if it was still good law, as you say, Ty, that it applies to the current codes and not future codes. But those are important conversations to have. If you moved forward with reviewing the changes to to the current code, the energy codes in light of 2066, I think those are questions that necessarily would need to be asked and potentially answered. My view is it's probably too soon to do that today.
And Ty, and Dustin, could you please put up the motion from November again? Just to be clear, we are already considering petition and amendment that could include I-2066 considerations in the 2024 code. That's already part of the TAG process right now. That's underway. And we're just trying to prepare ourselves that if needed, per that motion, do we need to open up the 2021 codes? Are we best prepared and ready to act quickly on that? And even to Greg's point, thank you for doing that, Greg, bringing real time some of the discussions that are happening in the TAG for the 2024 cycle could be prepared and ready for the 2021 if needed. Okay, thank you. Does that help, Ty? So
I'm not sure I'm 100% of the way there, but it does help. Thank you.
Okay, thank you. We're in motion on the 2024, no matter what. Yeah. Okay. Okay, Angela.
Okay. So I'm just trying to make sure I'm understanding this. We are not currently in an emergency rulemaking for the 2021 code, correct?
Correct.
Okay. If we choose not to enter into that today for the 21 codes, can the proposals that we have received sort of be accepted but sort of set aside? So, I mean, or kind of pushed down the road a bit?
That was the idea, that we've received them, we've acknowledged it, we've posted them. We want everybody to know exactly where they are, what they are, and we are sitting ready if needed.
Okay, so it's kind of like what Patrick had said, that if something happens like at the end of the year and things get reversed again, then these proposals would still be valid and sort of waiting for us to then take action and open the process after we've completed our mandatory action on the 24 codes, correct?
Right. Regardless, 2024, we're going to deliver and we're going forward on that. Yep.
Okay, but we could push the 21 down the kind of kick the can a little bit till after we've done our bulk of work that the TAG has signed up for, and then deal with the 21 after that legally. Yeah.
Yeah. I mean, I think we can say it that way, or we could say it as we haven't yet established that there's legislative mandate or emergency basis to go forward on rulemaking on 2021. Okay. And I see Derek thinking about what I just said there, so please correct me if
no, I'm thinking about why I can't say things as clearly and competently as you, Todd.
Well, we can still screw that up, so thank you. Shell, please.
Thanks. And I guess to Angela quickly, there is no can to kick down the road because the laws unconstitutional, the laws have been found to be unconstitutional. So I guess I'm just seeing that the transcript says that the outcome of the judge's decision is unconstitutional. We have a timeline for 2024 codes has been stated. We'd be better served by completing the 2024 codes before addressing, if we need to, the 2021 codes. We're staff and cost constrained sub-agency with volunteers on the council and the tags. I'm spending 7 hours every Friday with the commercial energy code tag. And pretty soon I'll be spending 7 hours every Friday with the residential energy code tag. And many members are on work groups outside of this 7 hours a week of volunteer time. And I just don't see that if we don't need to do something, we don't need to address I-2066, that we would ask them to do that, especially in the near term. So we've heard from lots of people. I'm ready to make a motion on this. I'm going to make a motion that we thank those who submitted petitions, we maintain them on file, and then send them to the appropriate tags only if 2066 is found to be constitutional and the council finds them relevant to compliance with that at that time, and that will be the council's direction in the future. So that's the motion.
Okay, thank you, Joe.
Second, Angela.
Second by Angela. Okay.
And just to be clear, you were referring to the 21 code proposals, not the 24. Okay, yeah, that is what
Correct.
this we talked about. Thank you.
Correct. Yep.
So second. Yeah.
And Chell, in your motion, can you clarify? I just repeat it again on who determines that it's constitutional? You're talking about the written.
Well, it's found by the courts to be constitutional.
Okay.
I guess yeah.
No, I was understood. I just wanted to make sure that it wasn't obviously established by the council. So
Yeah, the council should not be weighing in on the constitutionality, or at least not in a legal sense. Thanks.
Okay, we'll keep taking comment, but it's been moved and seconded for on action to the tags. Okay, go ahead, Katie.
I am in support of this motion, given our resources, given the indication from the courts currently, and our practice has been to follow the law as it stands. And that's where it's standing right now. But just to be clear, by setting this aside, that basically means that if we have to resurrect these proposals, all of the time, all the notice requirements would still be, they could just be resurrected and still meet all the notice requirements that they've already been through, so that it wouldn't have to start over again. That's the intent, right? Do you know what I'm saying?
I do, and I guess I'll weigh in and just give an opinion. I'm not sure any action is actually needed today. I think we're still going by the action that was taken in November, and that if needed is critical in my mind. So until we establish if needed or some, because I still have questions, Shell, on who and what we're sending this to. We say the tags, but are we sending it to the 2024 tags? We're sending, to consider action on the 2021. I mean, it would probably be the most logical, but I think there's still questions there.
Well, I guess.
I'm sorry, Chuck. I just want to be, if you don't mind me just jumping in real quick to just say, Council 2 would want to be careful about appearing to bind a future council to a specific action. And to Todd's point, I didn't understand, Chell, by the way, your motion to do that. I think you were careful to not do that, but there's some clarity on that point might be helpful.
Okay, yeah. The motion, and maybe it needs to be revised, but it's to thank people who submitted petitions, maintain them on file, and then I guess potentially send them to the appropriate tags only if 2066 is found to be constitutional and the council finds them relevant to compliance. And that's for the 2021 petitions that we received, both based on the November motion here, as well as a subsequent motion in a different meeting where we open the window for 21 proposals.
Yeah.
Is that a reasonable motion?
I mean, let's keep taking comment here, but again, I raise the question, is it necessary? I'm not disagreeing with it. I'm just saying, is it necessary to project forward, until we know more information? But let's keep taking comment on it. Roger?
Yeah, I have a question and then several comments. I'll keep it to a couple maybe. The change petitions that were published as part of the minutes, I would just like clarification that the pink colored code is the 24 and the blue colored are for the 21. Dustin, can you confirm that?
Krista, are you online to maybe?
Yeah, no, the color refers to whether it's a residential code proposal or a
Okay.
commercial code proposal.
So there are some code change proposals on this list that are for the 21 code and some that are for the 24 code.
The list that's published is all for the 21 code.
Okay.
Roger, if you remember, we deliberately separated it out because there was some question when we opened the 2024 code whether people knew that was also the 2021.
If you could bring up the list that was, my confusion is the title says 2024 master. So that's why I wanted to be clear that I understood what action we are taking. If you pull up what was published as part of the meeting minutes, it says 2024 master. So
Yeah, that is my error. I just added them to the end of the list and
yeah. So those proposals are the ones that we are contemplating with this motion. I just want to make that really clear. So given that clarity, I do support this. I actually feel like, Todd, we need to be clear that what steps we are taking. I have always strongly suggested and recommended and voted for actions that this council take that are based on whatever the current law is. And it is my personal opinion and interpretation that right now I-2066 is not current law, even though we haven't received the written. I think that the best path forward for us is to go under the assumption that I-2066 has been determined to be unconstitutional. Given our workload, I suggest we only proceed with 2024. I go back, and this is maybe what Ty mentions. I have always felt very strongly that I-2066, and I could pull it up, but the changes from I-2066 say that we cannot pass energy codes that blank, blank, blank. We have already passed the 2021 code. My opinion has always been that the first time that we would ever be considering the changes for I-2066 is when we pass the next code, which is the 2024. That has never been, as Dirk said, that's never been litigated or discussed, but that has always been my opinion and my reading of I-2066. And again, in addition to that, right now, I-26 is not current law. So I completely agree with accepting these proposals and putting them aside for consideration, as Chell mentioned. And I want to be clear, and I think it's been talked about, but my understanding is that if 2066 is reversed and considered now constitutional and now becomes law, what this council would do is we would go into emergency rulemaking. And there are a whole set of rules outlined for us that how we would handle emergency rulemaking. Very straightforward. It's like, okay, the law has changed. Now we have to go into emergency rulemaking and make changes. My opinion would still be that that would only be the 2024 code. Even if this gets, Patrick has said this is going to be sent to the Supreme Court. Supreme Court could rule in August, or it could rule next February or a year from now. We don't know. And we have no idea. So why are we going to spend a lot of time and effort being concerned about it? If that happens in the future, we will need to deal with it through emergency rulemaking. I also, in response to Patrick's, the need that suggestion that we would need to respond quickly if that happens. We have these proposals that we can bring to the table to whatever process we choose in the emergency rulemaking process. My opinion is we would have to open it up for additional proposals, because most likely the determination is going to be will the Supreme Court completely say that no, it is completely constitutional as is, or will there be some ruling that changes the language? We don't know. Again, it's something we don't know, but my assumption is we would again have to allow these another process to let people submit proposals to at that time under the emergency rulemaking process. So anyway, those are my comments. Sorry, Todd, I wanted to get
Roger,
them out there and clarity, and I am in support of the motion.
And Roger, I don't disagree with anything. Just clarify that I don't know that the council has established whether it would be under an emergency amendment in that case, or it would simply be a determination as a legislative mandate. I don't think it's necessary. I think the intent is understood either way. I don't think it's necessary to establish it today.
Actually, I think that the expedited rulemaking is directed, and it's 3405 353 1B. Expedited rulemaking is used if directed by statute. So I actually think, Todd, my opinion is that's what would be required.
Okay, I'm going by RCW. So if I mean
353.
It
1D.
Can I jump in real quick?
Sure.
Yeah, I think we've had some discussions in the past about what the right vehicle is.
D is in dog, not B.
Oh, are you talking about my name or me?
No.
Oh, okay.
What's up on the screen?
Okay. I almost took that personally. So listen, my point is I think we would need to analyze it when it happens, and that we shouldn't start to go down a single role right now. Although I want to be clear, I do, Roger, I do think that this is a potential option. Well, let's see what happens.
Okay, but thank you, Roger. Okay, let's go to Ian.
Yeah, hi, thank you. I just had a question. When this discussion originally started, there was reference to a couple of letters of opinion that were sent to the council, one being from Sierra Club and one from the Pacifica Law Group. And it seems those letters or documents were discussed by the members of the council, and maybe part of the influencing a decision today. And it's been typical practice that I've seen when these types of letters are submitted to the council that they're also posted on the website for public view. And I was just wondering if and when we might be able to get those documents posted for public. Thank you.
If I may respond to that one.
Yes, please.
I intend to get the proposals posted on an I-2066 website or page linked in our SBCC website. I'll intend to include all the letters. The reason they're not included for the meeting documents today is they were received by council within 24 hours of this meeting. So once we have an opportunity to post them, that is the intent, to post them for the public to view.
Okay, thank you for that. Okay, Tom.
Yeah, I was just wondering, if because of there are quite a few overlaps between the two codes, and some of these proposals do address issues that may be in both. Is there any efficiency gained by continuing to, vet those that do both and kind of solidify them for 21 if we do need to adopt them into that at some certain point?
Well, and I think to your point, Tom, I think Greg kind of mentioned that was his intent in some of his petitions, is to bring real time some of the considerations in 2024. Is that what you're implying?
Yeah, it is. And, and in effect, just kind of keeping that, in everybody's mind that, those that do apply to 21, that, they get discussed as a part of 21 as well when they're being discussed for 24. Just to save time from having to go through it all over again,
Yeah,
perhaps.
I agree. And I would anticipate if this was needed, we would look at options like taking this straight to the MVP and starting at the committee level rather than, and evaluating both together. So I think it's a valid point. Okay, Jay.
I don't know if others had comments on Tom's piece. I wanted to jump ahead. I had a different comment. Ben,
I
you're
did, yeah, thanks, Jay. So I guess, yeah, similar to what Tom had mentioned, I just wanted to clarify that the petitions page that was part of the meeting documents that we've been discussing, several of those do pertain to 2024 and are listed on there. So I just wanted to clarify that those petitions would not be removed from the 2024 review that the tag is undertaking.
And they're not, I mean, we're not in that first process of the 3-year cycle where we are used to normal petitions. So they're not limited to just those either, if we were to go down that process. So, but we wanted to make sure that we were very thorough in creating that option for external petitions and documenting that.
Gotcha. Okay, thank you.
Perfect, thank you. Angela, or no, Jay, I'm sorry, you wanted to.
I just
Unless-
had a quick comment for Tom's thing
Okay.
also, was that as far as like for the 21, I don't think we need, that tag needs to concentrate on, you know, the 21 things, because if they apply, I mean, these are already proposals are being revisions that are made to the 21. And therefore, if they apply to I-2066, when it's determined, or if it were determined that we needed to make changes to the 21, it could be looked at for the 24 saying, okay, these were already approved and would apply to this also. So I don't think the tag has to specifically double duty on them, in my opinion.
Thank you. Okay, Jay.
Thank you. I support the direction of what Shell's proposing in this motion of thanking the people that have submitted petitions and acknowledging receipt of them. Without seeing the language of the third clause, my concern is whether any, and maybe Shell, you can answer this, whether any future consideration of these is something that's automatic or something that requires future council action. My preference would be a motion that would say, we thank everybody, we acknowledge receipt of the petitions and archive them, and we take no further action at this time. And wanted to see or have Chell talk about his language and see whether that could be simplified, because I don't want to get into a situation where we're automatically triggering some action based on the appeals process without the full council voting again.
Thank you, Jay. Chell?
Yeah, thanks, Jay. And based on the discussion, I think that's appropriate. I'd like to modify my motion. And I do have a question about whether we need to conclude. Did we open a CR 101 for the 2021 codes to modify them or some type of rulemaking? And do we need to conclude that? That's a question to staff.
I believe that we are still needing to complete that, yes.
Wait, oh, I'm sorry, I missed that. Did my understanding of CR 101 was filed? Is that wrong?
Double check. Krista, do you have a track on that by chance?
I think it was, but I'm not certain because I was not the one filing it.
So if we could check on that, and then also if we need to conclude that in any way, formal way as part of the motion, because I think the motion based on Che and others' input would be to thank those who submitted petitions, maintain them on file, conclude the CR 101 process, and then adding that the council could potentially restart rulemaking if the situation changes and the initiative is later found to be constitutional.
And just to clarify for folks, there isn't really a CR 101 process. The CR 101 is the pre-proposal for rulemaking, and basically, stays active until it's formally withdrawn. The CR 101 filing doesn't obligate an agency to move forward with rulemaking.
So is it appropriate to conclude that process at this point from a legal standpoint, or is it, otherwise, does it die if nothing happens?
No,
Or,
it does not die. Legally, there's no reason to withdraw it or to not withdraw it. It's an administrative first step. If you ultimately elect you're going to do permanent rulemaking following the notice and comment rulemaking requirements under the APA in the future, it'd be good to have a 101 out there for it, but you could simply refile it. There's nothing that would prohibit you from doing that.
okay. So yeah, the modified motion would be to thank those who submitted petitions, maintain them on file, conclude the CR 101 process, and then note that the council could potentially restart rulemaking if the situation changes. I believe we need to get the second to agree to that modification of the motion. Angela?
Sorry, yes, second. Yeah, I agree.
Thank you.
Okay, thanks.
We have a comment from Greg.
I just had a question. So what about the EPCA violations? Are those not going to be dealt with now at all, or?
Yeah, so let me jump in real quick. I mean, I don't just for the council, I don't think anybody on the council would be conceding that there are any current EPCA violations. There is an active federal court case challenging the current code under EPCA that's currently pending in the Ninth Circuit on an appeal on an order dismissing that case for jurisdictional reasons. Whether the council wants to move forward to address potential risks under EPCA in their current code is up to the council, but I wouldn't want anybody to concede that there is violations of EPCA here.
And at the risk of getting into trouble in my interpretation of that, at a federal law, that would require the emergency amendment process. And it would not be the legislative mandate process in my understanding, but it's getting in the weeds. Yeah.
Yeah, Todd, I was gonna say it's a little weedy here, as
Yeah.
to the expedited rulemaking, but yeah, they're potentially, so if there is a court order declaring the current energy codes unconstitutional, I'm sorry, unlawful or preempted, right, under EPCA, then there would be pathways forward for the council to address that.
Thank you.
I also wanted to, I don't believe it's on the agenda today to address EPCA. I don't think that's the issue that number 6 on the agenda is bringing up. So, yeah.
It's a fair point. Okay. We have a motion and a second. If there are no other comments, does everyone understand the motion? Let's try, go ahead, Larry.
Is it correct to have a vote on this today when there wasn't anything in the State Building Code Council agenda that you were voting on something today addressing this?
No, that's the item here, Larry.
It's to talk about it, but it doesn't say anything that you're going to take action on it today.
Well, we do have the council action column checked there.
Yeah, but it's not addressed that you're going to actually take a vote on it today. So
Well, I'll defer to others, but I think we're within our.
Yeah, there's nothing under the OPMA which would preclude or bylaws or the other laws that would preclude the council from taking this action.
But thank you, Larry, for raising a question. Okay, let's try a voice vote. All those in favor of the motion signify by saying aye.
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 Any opposed? Okay, with that, we have adopted that motion. Thank you, everyone, for the conversation. It was, I think, important that we, one, got this out in a public process and took input but also, like always, had a thorough education on where we are and what we do. So, okay, it is 11:44. We don't have a lot left on the agenda, but I do think we need to take at least a 5-minute break. Can I propose that we come back at 11:50, please? Thank you. Okay. Sorry, I know that was quick and all right, welcome back. Sorry. I know that was quick and I probably doomed us by saying we don't have a lot left on the agenda, but we'll monitor on our side, make sure all council members are back for quorum. Moving on our agenda, we are going to discuss the WUI code, agenda item 7. Dustin, I think the intent here is more of an update, kind of guide us on what we would like to do in this cycle, if anything.
So, with the movement of the legislature this year to update the RCW 1927.560, there currently exists in that statute language that is technical in nature that kind of pigeonholes the council's ability to do specific, or I guess not specific rulemaking, but rulemaking to update that code, and the ignition resistant construction requirements will be static as a result of that legislative language as it is right now. In this legislative session, there was a bill to strike some of that and give the rulemaking authority kind of solely back to the council. Hearing throughout the years that I've been here so far, that the WUI code the process was rushed and a lot of confusion resulted in the process there, and the code received a lot of scrutiny and complaints about usability once it became active in the 2021 cycle. Suffered some issues in the 2018 version of the code as well. And then in 2024, legislation passed that says once upon completion of a statewide wildfire hazard map and base level wildfire risk map for each county of the state per the RCW, the WUI code shall consist of the following. Right now, those maps are not completed. The other component of this is kind of relates back to some of the stuff we've talked about earlier in this meeting, is should the council be undertaking work that is not necessarily required right this moment? And we are facing within the staff some timeline crunches that are, we're struggling to meet our timelines to cross the finish line by December 1st this year. And in my view, specific work to necessarily advance a 2024 version of the WUI code isn't necessary until the completion of these mappings is done. And but on another note, I do also feel that the issues that arose with this code in the 2021 version should be talked about to get ahead and bring in a more robust process. So what I would like to discuss here today is a specific, like a thoughtful process for this code, knowing that we can't get all the way down the road until the wildfire hazard maps are completed. What would the council like to do with this code? We have a tag that's being populated. It's not fully, all the seats aren't fully filled out on that group yet. And so, we're poised to start that work, but to get it across the finish line by December, I think is a tough task for us at the moment. And so we heard, similarly that the energy codes are having, 6-7 hour meetings weekly. There's work groups within that group meeting outside of those timeframes. So there's lots of volunteer hours going into the process there. And same with the WUI code and the other codes that we have going on. We're gonna have some long meetings ahead of us to get it done. And so my ask for the council today is to make a decision. Should we be trying to advance that 2024 code, knowing that, we don't have the maps and they're not not scheduled to be completed until after our deadline for completion this year. And that's my quick introduction. I'd be happy to answer questions if folks have them for me.
Thank you, Dustin. And stated another way is, and there are different interpretations of this highlighted section of the RCW. One interpretation would be we don't start anything until the maps are completed. It's very linear. We've heard that. The second is that we're trying to match that date. So we're trying to bring these together. The maps can be completed in one process that's underway, and the code can be completed in a process. And instead of December 1st, 2025, with the other codes, we're trying to align with when those are, because the statute says we can't adopt those until those two things come together. So that's really the discussion in my mind now. In the third is, of course, the resources to do that. But we are populating the tag. There are significant changes happening both in the 2024 and the 2027 amendments for the WUI code. So it's really the discussion in front of the council of what should our plan be to align with this statute. Go ahead, Roger.
Yeah, I have not read section 1927-560 in detail recently. My question is, and my understanding is in the current code, there is no WUI code that's been adopted. Was that a correct statement?
I would say that it was adopted and that upon passage of the legislation that brought in this mapping requirement, rules were filed to strike all of WAC 5155. That did lapse. There was a period where WAC 5155 technically a rule expired on that, and what we do have active rule right now, the status of WAC 5155 is that it is in a reserved state.
So there is no WUI code. If I were to want to build a house somewhere in the state of Washington, there is no WUI code that is required. Is that correct?
That would be dependent on local jurisdiction adoption, which is allowed towards the bottom.
Number 2.
Yes.
So if a county or city, and this, I'm asking this question, I don't know, maybe some of the city or county officials know this, but if the city or county were to adopt the ICC version of the WUI code, do they have to do their own mapping? Would they then have to determine what the mapping, what is required where?
That is my understanding. Yes, they would have their own mapping done kind of per item number 4 down here.
My general concern, and I have to say I'm not completely up to date on all of the requirements of the WUI code, but WUI code and the law, we are faced with more and more wildfires. We've seen the devastation in LA. We've seen devastation. I know there was a big Cheney fire. And I feel like having this council just kick the can down the road without putting something out is not prudent. I am completely I recognize the challenge of the staffing, and I'm constantly trying to do anything I can to help the process and move things forward to make sure our staff can do what is required. But if I just take a step back, I feel like as a state building council, building code council, we should be providing some basic level of code adoption. And I understand there were problems with the last code that was adopted, but that's just my general feeling. And I'm not exactly sure I'm suggesting how to proceed. I just want to put that out there that it is I think it is a very urgent need for us to deal with. And it feels like we're kicking the can, and I don't think that that's right. So.
Okay. Thank you, Roger. Let's go to Ty.
So thanks, Roger. You made reference to like local city and county. So I know when we were tangling with this, whatever it was, a year and a half ago or so, my local jurisdictions, one of whom I think Tumwater folks were actually part of the lead for the whole city, Association of Cities. So they were kind of really dialed in, but I'll just speak for my local jurisdictions. We're very relieved that the WUI code was stricken in the way it was, because not only the mapping, but they had concerns about defensible space requirements and how it would apply like across Tumwater and whole parts of Thurston County. So I guess I just want to say that using their expertise as an example, a rushed code was worse than no code, and they were super relieved when the legislature took the action it did. So I would want to make sure we have a lot of questions about it. It has to be really dialed in our perspective. It has to be, we have jurisdictions all across Western Washington working on carbon sequestration. My county has invested millions of dollars literally into tree canopy assessments, forest conversion ordinance, on and on and on. We're litigation with DNR about how our older forests are managed. So we have to be certain that this code is dialed in at a very narrow, covering the safety issues, but no broader than that, or else we're just basically undercutting our own efforts on multiple other fronts. So I know from my local jurisdiction's perspective, no code was better than what we thought was going into effect a couple of years ago. So I want to make sure that we do this in a way that's done right with best available science. And if that takes extra time, I'm for that extra time.
If I can respond, and Todd.
Yeah, go ahead. You can go about it.
What I do want to point out and ask the question. If we are not doing anything about this code, you mentioned the 2027 IBC. If we take no action, am I to assume that, and I understand Ty's concerns, and I am supportive of them, and I understand the challenges that were asked about the last code that we passed. But my point goes back to doing nothing. Does that mean we're not going to do anything until the 2027 code will get adopted, which is what, 2030 or 31, something like that? And again, that seems like a real long time for the state, the people of the state of Washington, and not have any code for something that wildfires is a very, very large threat. So.
Thank you, Roger. Thank you, Ty. Tom.
Yeah, similar to what Ty was saying, in Whitman County, we don't have a lot of tree canopy, to worry about, but, dry wheat burns just as well and travels quite fast. And so, we're finishing up our mapping and all of that. I think that it's real important that there is some higher level guidance that could come down to the counties and the local jurisdictions on some of this stuff, even if it's in the interim, that we could use and adopt, or adapt to, if we adopt the international code. pretty much what is, from what I recall, what derailed the whole WUI code thing the last time was the defensible space issue. And I think that if nothing else, the council should start working on that piece of it, and see how far they can get. So that would be my recommendation, that we not do nothing, but we start working on the tough parts, and make some progress on it.
Thank you, Tom. Go ahead, Jay.
I appreciate the concern on the broader issue that Roger brings up, but have a disagreement with the fact that says if the state building code council does nothing, that there is more risk or more exposure. One of the problems we had with the WUI code was getting the right statewide standards that applied for the areas that are traditionally at wildfire risk without impacting the more urban cities that might be adjacent to parkland or other areas that got swept into some very imprecise maps. And so what we have today is the case where jurisdictions can adopt the codes that they need to for their own wildfire protection. And hopefully Angela and others involved in that can talk about what jurisdictions have authority to do today. But I don't think that given all the work that we already have lined up this year, that we can make progress on this without the map, because it ends up being very complex to set a statewide standard that works with somebody that's up against forest land without dealing with cities and counties that are really just looking to preserve trees. And so I'm skeptical that we can make any progress as Tom suggests, given the other workload, and would prefer to just defer this to when we get the maps completed, because this is work that's got to happen in conjunction with the maps. And that was the problem that we made last time, that we made the code before we had the maps. Thanks.
Thank you, Jay. Angela?
Okay, so I guess I'd like to point out that with or without DNR's new maps, currently SBCC has no jurisdiction over the WUI code. We cannot produce a WUI code. The legislative bill that was put in that would have given the power back to us after the new codes were done did not pass. It died, as far as from what I remember talking about with our stuff. So currently, even once the maps are done, it reverts back to the structure hardening requirements that are in the RCW. And that's it. Those are set in stone. They don't change until the legislature goes in and changes them. There's no mitigating them, anything like that. Those are what are in place, unless local jurisdictions choose to adopt the IEB, international, whatever it is, the I code, the base code, or portions of it as it sees fit. But there is nowhere in the RCW that says that SBCC can create a code for adoption. It took it away from us. I mean, there are very limited choices that jurisdictions have, and that's even after the maps are actually developed by DNR. So until next January, and that bill comes back up into legislation, for the legislators to look at again and figure out if they want to implement it, we can do all the work we want, but it's going to sit. And I'm not saying that we shouldn't do anything, because again, I think Mike has brought this up a number of times. He did a lot of work on the last one, and it does take time to properly create this WUI code. And last time, the big problem were the maps themselves. but that mapping, what was in those maps was actually, again, directed by legislators. They said what kind of maps needed to be done. DNR did them, and they didn't turn out to be what anybody thought they were going to be. So I think we could do basic work on this, but without seeing the maps to see how it's going to affect, how much area it's going to affect. We can't do a complete job with this. So as to what Jay said and what local jurisdictions can currently do, if they adopt their own maps, which I do think means they could use the DNR maps that were produced if they chose to use those as their local maps, or they can create their own, which some jurisdictions have, then they can use the I code or portions of it currently to mitigate their areas. But so that's kind of where it stands as far as just if SBCC does nothing, that's where our hands are tied. We have no jurisdiction to actually officially do anything. So that's, where we're at on that. So I just wanted to clarify. Sorry.
Okay, go ahead. Thank you. Go ahead, Katie.
Yeah, I've been thinking about this a lot, and I'm torn about it as the chair, because on the one hand, I do hear, Angela, what you're saying, and the fact is that we have no maps in time to get it out on time for the 2024 code. We have no authority to even do that because the maps won't be ready. But interestingly, like the one jurisdiction that's asking for some guidance is Whitman County, which Tom, it is a smaller county. I don't know what resources you have to do the mapping that would be good for your county. And you're in a county where the risk is high. And so I want to honor that request that we slow roll this language so that we will have had some of these discussions when the maps come out. In talking to the DNR folks, it sounds like, they're aware of the issues that have come up in Washington, but then also in Oregon. Sounds like they had some issues as well. So they're trying to put out some really mindful maps, I think. And the slowing things down does seem like it. I understand the risk with California and what happened in Cheney and in Elk over here. So, we talked about potentially getting the tag together for a couple of meetings to go over the significant changes report and maybe highlight some of those issues. Like we talked about the defensible space issue really being a major kind of stopping point in the 2021 conversation. And so to have all of that discussion kind of teed up for when the maps get here so that we know, because we wouldn't do an emergency code. What would we do if the maps come out on December 31st, 2025? In January, would we then try to open up a off-cycle rulemaking? Would that be the pathway? Is there that, like, I know that December 1st is sort of our first big deadline for the rest of the code, but then it does seem like things steamroll from there. So I'd be interested to know what, Dustin, you think about and what our path forward is once the maps do come out. Is it just an off-cycle rulemaking?
I guess we have some guardrails on our process that, we have our 3-year code adoption cycle. We have an option for an intervening cycle 1 year after implementation of the codes. We have the expedited rulemaking process, and then we have emergency rulemaking processes. I think that once the maps are out, we could go down the normal rulemaking process, or we could even embark on it now, but it wouldn't be part of our normal 3-year cycle. This is directed by the legislature, but it says, you know, once the maps are done, the WUI code shall be composed of these parts. If we analyze what is in this legislation as far as the technical provisions, these provisions align with the most restrictive ignition-resistant construction requirements in the WUI code. In the model code, though, there are 2 classifications that are a little bit less restrictive than what we have here. And one of the other components that I think is relevant is, and it may not, we haven't officially taken a position on it, but the thought process is that any amendments by a local jurisdiction may not be allowed on this code if we haven't adopted a code. So any amendment by a local jurisdiction that affects residential construction must be approved by the SBCC before becoming effective. And by that notion and the stuff that we've talked about earlier, that we have no jurisdiction to adopt this code until the maps are done, limits us in our approval authority for local amendments to this WUI code. So as we, you know, I believe that a discussion should begin, but we shouldn't be shooting for a target that is to finish by December 1st this year. Another thing I'd point out in this legislative language is that there is no mention of defensible space in here. So that was one of the comments that came out of the turmoil experienced when the 2021 code was in effect for Washington, is that lots of folks pointed to the fact that there's no mention of that. And up higher in this legislation, it says, you know, this shall consist of Chapter 1 and these following technical provisions. There was some criticism that defensible space was included in the WUI code adopted by the SBCC. But it, you know, I wasn't around during the development of that WUI code, and don't know if defensible space was considered as part of that rulemaking process, but it may be the intent behind this legislation that defensible space isn't required, but we, in order to compensate for less defensible space, which allows wildfire to get closer to a house, building hardening at the maximum degree in the code is what's required to mitigate that risk. So for the process moving forward, you know, understanding that we can't finalize our adoption without the mapping to integrate into that consideration, I think discussions could start, but what I guess I would call a turbo process to get it across the finish line this year is not feasible for a couple reasons. The discussion that needs to happen right now is likely going to be a contentious one. You know, when we talk about the environmental impact of defensible space and what was required in the WUI code as last adopted versus the cost of building hardening, you know, I think that there's 2 sides of the coin there. I think that they could interplay at different levels, but that's my own personal opinion. And I would like to start talking about it, but I also am nervous to try to say it's going to happen by December 1 this year. And, you know, I just think that a little bit more of a slow burn on this process is what's required, and maybe taking it outside of our 3-year adoption cycle is what is most prudent in anticipation of the mapping not being completed until, you know, essentially midsummer. You know, it could come up a little bit sooner, but we are kind of beholden to those maps before we can really adopt. So just trying to, you know, be thoughtful about the process that we are embarking on with this code. You know, for such a small code book, it has proven to be very contentious.
Okay. Okay, we're piling up on hands here. Let's go to Patrick. Thank you, Dustin.
Thank you. Once again, this is Patrick Hanks with the Building Industry Association of Washington. I want to note that I see that on the 1st of this month, the SBCC filed a CR 101 WSR 2508084 for adoption and amendment of the 2024 WUI code. But reading RCW 1927-560, I don't see what basis you have to even start that rulemaking until you have DNRs completed the statewide wildfire hazard map and the base level wildfire risk map for each county. I think that's important because trying to preload and get code language work done before those maps are completed, those maps are going to ultimately determine who will be stakeholders in this and to what effect they will have a stake in this. So it's possible that if you try to do code making before those maps are completed, there may be jurisdictions that weren't anticipating being impacted or to what extent they would be impacted by the code. Then having, the council tag may say, well, we already decided on this, so we're moving forward with that. I think it's better if you wait, and also with all the council members that have expressed concern with the staff workload and the burden you're putting on them trying to get the 2024 code cycle done, it seems like you're trying to start something that you don't really have a statutory basis to do, and then adding on workload for what likely won't be able to be completed for the 2024 code cycle. So thank you.
Thank you, Patrick. Angela?
Okay, so I guess I'm getting confused on what we're kind of doing, because so like Dustin made a statement that we don't have the ability to adopt the WUI until after the maps are done. But nowhere in this legislation does it say once the maps are done, SBCC gets to take control of the WUI again. Once the maps are done, then this section 1 goes into effect, and local jurisdictions have to either adopt those maps, the DNR goes out, or they have to make sure their maps that they've been using are modeled using the same sort of criteria and process. And then still they can use the international WUI or portions of it. And in section 2 or 3, somewhere down there, it also says that no amendments can be made to the codes that make it more than the minimum that's shown. So international that is more than the minimum performance standards and requirements contained in 1. So you can't, even a jurisdiction can't make it more restrictive, is what I'm reading that as. But again, we're talking about once the maps are done, we need to get going so that we can adopt a code. The code's adopted. The code is this piece of legislation. It tells you it's hardening, or your local jurisdiction has to adopt the base code with, I don't know what kind, as a whole or parts of. So I guess I'm confused by this whole, we once the maps are done, then we're going to adopt. We're hoping that next January, that same piece of legislature that Dewar came up with this year is going to pass, which gives the power back to SBCC to actually make amendments and do things. But as it stands with 1927-560, nowhere in here does it give the power back to SBCC again. It just says once those maps are done, now section 1 and the hardening applies, or you have to take it upon yourself as a jurisdiction to adopt the international WUI. So I'm getting a little confused on what we're talking about on these next steps, because until next legislative session, SBCC still has 0 jurisdiction over the WUI as far as what I can tell. And again, maybe Chell or whatever, maybe I'm wrong, but that's how it's been being read. So
Thank you, Angela. Katie.
Yeah, Angela, I think you're making a really good point. And I've been also struggling with like, okay, how, if we're going to get together and talk about this, what exactly are we going to talk about? And so I was thinking, what if, to your point, we don't have guiding legislation, if the structure of these maybe handful of meetings, hopefully not that many, were to go over the legislation for next session that would, and say, you know, we can present an idea, and I don't know if we're allowed to do this, so this is just like maybe thinking outside the box a little bit, but that we would present an idea to the legislature to go, this is the legislation to get us back on track with WUI, that and by then we would have some of the maps, hopefully, and so that then that would guide our conversation when and if it's a year after we adopt 24 code, or if it's even 27. But could that be a way to guide our conversation if we're going to get people together with a so that we could direct a tag to do something that it actually could have the power to do? To your point, Angela, that you're right. This is saying the International WUI Code is what takes effect upon the maps being completed. So
can I jump in for a second?
Yeah.
This has been a really interesting conversation, and I appreciate the opportunity to listen in. I do want to say one thing, though. As I read this statute, these provisions of the statute don't become part of the code by operation of law. There needs to be an intervening step, namely the council needs to adopt the codes, these provisions of the code, that when the time is right, into the building code. That's just the way that the codes work. It's also required under the amended 1927-031 subsection 4, which provides that only those portions of the International Wildland Urban Interface Code specifically referenced in RCW 1927-561 or the Model International Wildlife Urban Interface Code specifically referenced in 1927-562 shall be part of the codes. But that's it goes on to say that the codes enumerated in the section shall be adopted by the Building Code Council as provided in 1927-074. So there is a necessary so that there's no confusion about this. There's an necessary intervening step of the council affirmatively adopting these provisions into the code once the statewide mapping is completed.
Thank you, Derek. That's helpful. Jill.
Yeah, the question seems to be what we do in 2025. It appears we can't really adopt the WUI code in the near term in 2025, and we have staffing and volunteer capacity issues in the near term. So I think we should start on this in 2026. I think we should proactively look at how a code might do this, but I don't know. I think we can do that without taking a lot of staff time. If we want to prepare for the 2026 legislative session, I think we could do some proactive steps to work with legislators ahead of that and figure out what we would like the legislation to say so that it would pass and then give the right authority. I think the issues with the WUI code go well beyond just the defensible space. I think there were a lot of other issues with the code as a code, and then also as it would have an effect on buildings. So I think we should functionally work on this at the tag level in 2026 and not this year. But we could, I guess, strategically figure out what we want the legislation to look like this year so that it is presented in November and December to legislators, which is when, they're really looking at potential legislation for the 2026 session.
Thank you, Chell. Roger?
Yeah, I started the conversation. I'm hoping I can end it as well. I agree with Jill. After Angela's comments, reading through the provisions, I'm once again reminded how disappointed I am in the legislature that our hands are tied, that we can't take action. And also I feel like the legislature have put the people of the state of Washington at risk because of that. So, and I think the conversation we've had today has been good and productive in at least getting that out in the public realm. I agree with Chell. I think the staffing and the main work that we would and or could do should be a 2026 task. I also would recommend that the legislative committee work with whomever in the legislature to try to move this forward so that we can do everything we can in order to try to get a reasonable and relevant RUI code out to the public as soon as possible. And I would go back to if the law changes next legislative session, we can always take emergency action. We can deal with it at that point. And we don't know what would come out of that legislation or exactly how it would be worded. So doing work ahead of time would be counterproductive. So that's it.
Okay, well, thank you, Roger. Although I'm not going to give you the last word. I do have strong opinions on this, and appreciate everyone's input, obviously. I would advise and like the council to move on from talking about maps in the previous cycles. Most of this council wasn't here, and it's not our focus right now. And I do take a little bit of issue with attacks on this council. There's been a lot of misinformation in Olympia attacking this council. The intent and the effort put in by stakeholders, not just the council members, but the stakeholders in that it was dealing with a difficult situation as we are dealing with a difficult problem right now, trying to work our way around statute and work our way around what we are tasked with doing and the responsibility that we have. And I know we all take that very seriously. And I think beyond just the pathway of how we do this, regardless of the legislative mandate, we have a responsibility for the health and well-being of the state to guide this. And how we do that is dictated in some ways in our adoption and our process with tags and so forth. We also have bylaws that say we have standing committees that are responsible for doing research and being prepared to and being experts in the codes that they oversee. We have mechanisms for creating special or ad hoc committees that can form work groups and so forth around this. And I think we need to do that. We need to probably look more to what action the BRFW committee should be taking and relying on the tag of subject matter experts when necessary. So I think there's a lot we can do. And I think anticipating not just for adopting this code cycle, we're going to get asked this summer in the interim on informing legislation coming into next session, just as we did last summer. And we have to be prepared if we're asked to inform this. So I don't know what the answer is. I just want to put it out there, kind of a different take of we need to be prepared. So, okay. I will step down from that, and I won't get the last word because we're going to ask Tom to give the last word here.
Sorry. I actually totally agree with you, Todd. I think we need to move forward in some manner with it. We're just coming up on another wildfire season here. And if something were to break out and there were a big one, and we actually were just standing down and doing nothing, I think that we would take an extreme amount of criticism for that too. So just my 2 cents.
Thank you, Tom. And we don't have to take action today. I think the intent was we raise this concern again, talk about it as a council in a public forum, and take public input. And that doesn't have to stop today. With that, I don't see any other hands. And unless anyone wants to take any action, we can close this item and say that was more education today. Thank you. Okay, moving on in our agenda. I don't have it in front of me, Dustin.
Tag appointments.
Tag appointments, okay.
So we have on here, this is a little bit updated to what was posted online with an additional tag chair recommendation. The names on here have not changed. We have received a couple more applications since this document was created, but in the interest of not confusing what we were handling in last week's canceled or adjourned council meeting, we didn't include those new applicants on this document just to keep this one going as streamlined as possible. So within the energy code residential tag, we don't have any new applications and the seats are mostly filled out there. Within the residential code tag, we still have a few vacancies here. We've got the architects, the general contractor developer seats, manufacturer supplier, mechanical contractor, insurance realtor appraiser, and construction trade seats are still vacant. We have some alternate seats still open within that one. Within the single exit and multiplex housing tag, we have some new applicants. The blue stuff that we see here are changes as proposed by the chair of that tag. And so for a structural engineer, we have Michael Wright who applied. We have no other applicants. And so we've made a recommendation concurred by the chair as a primary for that slot. Within the building owner property manager slot, we have Jesse Bank proposed as the primary. For low-income housing expert, we have Shweta Sinha as a primary for that slot. And then for fire official for the counties, we have a primary already in place there. And we received a new applicant, David Lynham, and we're recommending him for an alternate slot. And then at the fire officials for the cities, we have a primary in place there, but we have an alternate recommended for that slot, which is Rich Geiske. And would we want me to just run through the whole sheet and we can maybe take them as a whole, or we want to do them tag by tag?
I think that's fine unless anyone raises their, yeah.
Okay, I will keep on rocking. Within the WUI code tag, we still have lots of vacancies here. So we have the architect home designer slot, general contractor or developer slot. We have landscape architect slot, and then Jesse Bank as a city's or county's planning representative. We have a recommendation for him as a primary there. And then we still have opening for the insurance realtor appraiser slot, and then plenty of room for some alternates within this group as well. Within the IFC and Energy Code Commercial, we don't have any new applicants, but also within the IBC tag, we looked to appoint Shweta Sinha as an alternate to the affordable housing representative there after Todd Sullivan. And so those are all the applications we have to date. The next time we bring this to the council, I would like to have a representation of all the tag seats that are filled there so that we can see any vacancies that are there. We do have a tag roll sheet posted on our technical advisory group page. But this particular sheet here has links to the applications and letters of recommendations if we've received them. And so I'd like to have a better representation because now we're in a situation where we're no longer necessarily in a group 1, group 2 scenario. As the codes advance, we've got some more work with dwelling unit size stuff for the IBC that needs to happen. And so the IBC is anticipated to meet a little bit more here in the coming months to address some of our other legislative tasks. And so as I just want to move forward looking at the entire 2024 codes tags, and that way if we have interest from other groups, and there's always the chance that we get opinion requests as well to go to the tags. So it'd be good to continue to try to fill out any other slots in the other tags that are were in group 1 and may be in a lull as far as their workload, but there's always the potential to convene them as needed. And so with that, that's what we have for today's consideration. Is if we'd like, we can go back and look at anybody's application documents as needed.
Go ahead, Tom.
Yeah, I've got one question, then I'll make a motion. Do you know by chance if there's pretty good representation east side, west side on the WUI code, being that the wildfire concerns are different on each side of the state somewhat?
I don't have good data on that right at my fingertips, but I am familiar with that. We have some folks from the east side definitely represented within the WUI code. Dave Cocott hails from Spokane.
So does Jesse Bank.
And
Yeah.
Shane is Cheney.
Okay, good.
Yeah.
All right.
Lance Dahl is Spokane.
Spokane Valley.
Spokane Valley, thank you.
Okay, that's good. That answers that question. I'd move then that we adopt this list as presented.
I'll second it.
Okay, it's been moved and seconded to approve the seats that we reviewed today. Any other discussion? Okay, if it's that easy, all those in favor signify by saying aye. Oh, wait, Patrick, hold on. Patrick raise his hand. Ken second. Go ahead.
I'm confused. Is this two different Jesse Banks, or are you moving Jesse Bank from 4 to 12?
Oh, good catch there. What are we, I think the intent there was Jesse was more appropriate under the cities and counties planning. That's a nice catch, Patrick.
Let's just double check that. It might be a mistake on our part. We got Jesse Bank from Spokane.
Yeah.
That's what I remember as well, is we moved him down there just to fill out the voting members as much as we could. And his planning commission work really makes him a great fit there.
The same person, and the intent was to get him in a primary slot down there to fill out voting members.
Yep, that was our intent. I don't remember what meeting it was, but we discussed this, and thank you, Patrick, for catching that.
I think we had this at the last executive committee meeting. We discussed that.
Okay. Okay, Patrick. I'm sorry, Ken.
So I'm just speaking as the SME, not as a Seattle Fire Department representative. Since I am mentioned on the tag here, I am a little confused. You're establishing a tag for no work right now because your previous action was just you have no agenda set up for this 24 code review. It's not on the schedule, but we're putting together a tag. So I'm just trying to understand the philosophy of this, of why, and if I don't understand it, then I'm probably just going to remove my name from it, because I have no idea what direction we're going besides nothing right now. We have nothing to review, no meetings to establish, but you want to have a tag set up for it. So help me understand that again.
May I comment a little bit?
Of course.
While we don't have a specific path forward to develop a 2024 code, there, I guess, is always the potential for a local jurisdiction to reach out for some interpretation services by the council. A lot of times that can be handled by the committees responsible for the specific codes, but I think it would be valuable to have a group of subject matter experts on hand, should that need arise. And should the legislation shift next year, it would be good to have this group already established. Because that is the end of our 2024 cycle in the year 2026. And then in 2027, we would establish a new group depending on, the environment at that time.
Okay. Ken, does that help? I mean, we still need to land this plane. We're just trying to
No,
determine when and
no,
how to land it.
It's your guys' call. It's just this what if scenario. Okay.
Okay. And we would value you on there, please.
If I may, I would even suggest there is a strong possibility, and here I go, I'm somebody that says we should only be taking action of things we know, but I would think that there's a strong possibility that we will be asked in 2026 to get a WUI code of some sort, even if it is the regurgitation of the current RCW, and get it published in the current code cycle. So that could very well come out, or actually the interpretation that we heard today of the RCW is if the maps come out in January, I think that people will be assuming that we are going to issue a 2024 WUI code, as Dirk said, that regurgitates what the RCW says, but I think that we will have to have a tag ready to do that. And, getting the tags populated and up and running has typically taken us a 2 or 3 month period. So I could see us being under the gun next year to try to get through emergency rule or something, react to either the maps being published and or new legislation with a requirement to try to get work done this code cycle for the 2024 code. So having the tag organized and functioning ahead of time, I think, is prudent.
I think it's a good point. And just to reiterate, though, we do have to write the code still. So there's going to be a petition, including the RCW statute, or something similar language. And as we experienced in the EV chargers, we don't necessarily just go word for word. We have to meet the intent of that law, and it might include a lot of that language, but we still have to put it into code language. So, okay. Hopefully we convince you, Ken, to hang in there.
It just this, the 7th month delay. I don't know how many of these people are still going to be available when you try to pull them together in January.
It's a concern of all of us too. Agreed. Yeah.
It's because a lot of these people thought we would be working on this for 24. But obviously you guys made a decision not to do that. So we'll wait.
Yeah, I think, Ken, it's a valid point, and the discussion today was hopefully to get it closer to. Now we have an established date certain and the glide path to get to that date certain, but let's get closer, right? I think at this point we're not assuming we're pushing off 3 years. It's maybe another way to say that. Okay. Anything else? We have a motion and a second to approve the list as reviewed today on screen. All those in favor signify by saying aye.
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 Any opposed? Okay, we've made those additional tag appointments. Thank you. Okay. Sorry, if you can pull the agenda up, please. We're on to agenda item 9, which is committees composition. Dustin, I think the intent here was to review our vacancies on the current tags.
Yes.
Yeah.
So this is the same document that was introduced in 2024, so it's the same format. Running through, I wanted to go over the chairs of the tags real quick because I believe that at some point Roger expressed a desire to maybe not be included as the alternate on the fire code tag, and I just wanted to affirm that that role. And so I have him highlighted here, and then with some other vacancies, we have some of the other chairs and alternate chair, I guess alternate chairs only within the tags are in a vacant position right here. So I guess starting off with the fire code tag, I just ask Roger, are you still available to serve as the alternate on that tag?
I will actually make myself officially not available, given my IBC, BFRW, and single exit work is, I would like to be taken off of the fire code tag.
And would we have a volunteer to serve for an alternate chair within that tag?
And Dustin, remind us, is it required that we have an alternate?
It's not, well, I guess by our bylaws, yes. So here below all these different groups we'll look at today are the bylaw components that kind of guide how we are populating them. So the technical advisory group shall be composed of at least one voting and one alternate council member and one voting member representing each constituent group designated by the council. So we have the seats that we put together for these tags, and then we've had the alternates, and the goal by having an alternate there is to have, you know, some folks that sit on the actual board of the council present at each meeting. That way the, you know, decisions made at the higher levels can be informed by those individuals as well.
Okay. So do we have a volunteer, knowing that this tag is substantially complete for the 2024 cycle?
I
See a
will,
hand up.
I'll volunteer as long as it doesn't require a whole lot of work by me in the next couple weeks.
I think that that's a safe bet on that one. You know, I think anticipating what might come down to this group is potential emergency rules. We have an emergency rule request we just received that we'll entertain at next month's council meeting. And just minor discussions. I don't think it's going to take up a ton of everybody's time on this group moving forward for the rest of this code cycle. And I appreciate your volunteering for the abuse, or not abuse, it for the service to the state.
Thank you, Angela. Okay. So energy code. So,
Energy
but
code commercial tag. Last year, we experienced a vacancy on the council that, to my knowledge, hasn't been experienced before. We had a member pass away, and so by that motion, or that trend, by that happening, Craig Holt is no longer with us, and we have a vacancy on the energy code commercial tag for the alternate chair. And so I'll be looking for alternates for both of these, the energy code tags. Damon Doyle, I have really appreciated working with him in his time here, but we don't have a reappointment for him, and so his seat on the council is also vacant at the moment.
well, and Damon, you have your hand up. Well, Damon, why don't you go first, and I'll weigh in.
Yeah, thank you, Todd. I would hope that somebody would move to postpone a decision on these till the next meeting. I know that the governor's been overwhelmed. It's been a active session, and I'm hoping that by next council meeting, both of these seats should be appointed. I know that the names have been submitted. I think we're also missing a city elected position on the east side as well. So it may be premature to do anything today on this.
Damon, I was going to kind of reinforce that especially since we know you'd want to be in that position, and there's not a determination. So
yeah, Todd, I bumped my head and still want to be on it. So yes.
Yeah. Okay. So I guess that's the alternative. We just
hold off on all the committee or all these appointments for the moment. I mean, we're not necessarily suffering from the inability to do business without these positions being filled. Just it is nice to have them kind of rolled out. And we can review the rest of this, if that is the desire of the council moving forward. So the remainder of the tags, have the prime and alternate chairs assigned. Looking at the Building, Fire, Residential, and WUI Codes Committee, looking at this one, there's no specific number of council members required on these committees. I do have down here, up to 7 members maximum. That's in the spirit of not forming a quorum of the whole council within these committees. So we have some folks here, and we have a vacant spot as a 7th council member with Todd. You were on this one, and I believe I may be mischaracterizing this, but by becoming the chair of the council, that it kind of puts you into the same role twice on this council or on this committee. And so just trying to get good numbers for this committee, I have kind of characterized where everybody's sitting here, and we have a 7th spot vacant. For the MVPE, the Mechanical Ventilation, Plumbing, and Energy Codes Committee, we are sitting okay with the slots here. We'll see that Chell's listed twice, but I only have him on here as number 2 twice. So we still have 7 members of the council representing that committee. Looking at the Legislative Committee, we have the same thing with Todd here. Once you became the council chair, this specific slot became vacant, so we're lacking a 7th person. And I'll pause for Krista. She's got her hand up.
Actually, Jay is not the appointed chair of the MVPE tag anymore. That is a vacant position right now. Because Damon had been chair. So that would take some council action to reappoint Jay as the chair.
Go ahead, Jay. Thank you, Krista.
Yeah, and I'm happy to do it if folks are comfortable with me being both vice chair and a chair of a committee. Also open to others if they want to take over the chair point. I was also going to mention that in the next committee, when we get to it, I was listed twice for the Legislative Committee too, so we have another slot there.
I have you as number 3 twice on this one, so we're still trying to make a total accounting. The reason I have you in there is just this Legislative Committee shall be composed of the council officers, chairs of the standing committees, and other voting members of the council as appointed by the council chair. But with what was just characterized for the MVPE, you would only be on here once, so we would just remove that line.
Got it.
Well,
thank you.
And on the MVP, again, the same situation. I leave it to the council, but I think I'd be uncomfortable. We've appointed Damon as the chair of that. And out of his control, we just don't know if he's reappointed from the governor, right?
Correct.
We just took that action in January, if I remember correctly. So Ty, why don't you go first and go ahead?
So I'd be interested in that open position on the Building, Fire, Residential WUI, provided I don't like to take on things I can't meet. So is there a particular schedule, day of the month, or how often does it meet?
We've been meeting monthly as needed. So the meetings are regularly scheduled on the 2nd Friday of each month until we get towards the end of the year this year. And, bringing opinions and reports from the tags up to that committee is kind of where the work levels lie in. But we are kind of intending, should the work be needed, to meet every 2nd Friday.
So I have a morning commitment every 2nd Friday. Is it afternoon or morning?
It is in the morning, but we could entertain a shift there to bring the MVPE committee to the morning and put the VFRW in the afternoon, should that work best for everyone's schedules.
Okay, well, if that's something that's out there, I would volunteer for that. If it's gonna stay morning, I wouldn't be able to do that. So thank
Let's go to Angela first, and I'll go to Larry.
I would be interested in the legislative committee position. I try to attend them anyway, but
Yeah. I kind of forgot, Angela, you weren't on there because you attend them all. So thank you. And then are we certain with Matthew?
Well, we don't have a reappointment for Matthew Hefner at the moment.
And I forget formally, has he indicated he does not want to be reappointed?
I don't have a formal on that one, but I've heard rumblings.
Okay. So just hold on that, but maybe flag it. Okay, Larry, I'm sorry. Go ahead.
You know, I see this as being a perfect example why you should have more members in your committees here, because you're working people, volunteers extremely hard. And I would hope that maybe next session that you would take up adding more members to your system so the work is spread more evenly, less to everybody. And in your last time when you voted on this, you were in opposition of such a thing. But it's clear and evident that you need more people on the council so they can staff the committees better and there isn't such a work burden put on everybody. Thank you.
Larry, just to be clear, are you talking about the whole council?
Right, the whole council. Right, you guys voted against that this past fall when it came up in your legislation committees that you didn't want to have more members in the council.
Okay,
it's clear and evident here that you really do need more members, especially because you have them coming in and out at different times. See, and by having more members would put less work on your staff, on you people, and it'd give a better chance for a more even approach out there. Thank you.
Okay, thank you, Larry. I understand now you're referring to Senator Short's bill in the legislature. Okay.
I would like to also clarify that we didn't vote to oppose that bill. We were neutral in there. There was concern expressed at the legislative committee meetings on the potential to add more members, but no official stance was taken by this council to oppose that bill.
Okay, seems correct. All right. And then are we gonna?
And we have the executive committee composition. This one is not necessarily volunteered for, but if you volunteered to be chairs of other committees, the executive committee is composed of the council officers, which is the chair and vice chair, and chairs of the standing committees as well. And so by what we do in the other committees out there, this particular committee is brought forward. And I see Jay's hand up is probably going to mention that he's got on here twice. And I would highlight this as something that we'll take care of when we get somebody in on the chair as the MVPE committee officially. And so right now this is a vacancy.
And I just want to revise my my statement. I think given that the executive committee is set up for the chairs of the committees, that it probably would be better if we had a different council member as chair of the MVPE committee versus me. So I wanted to withdraw from that. Thank you.
Okay, thank you, Jay.
Then we have the work group of economic impact. That one is also one that is composed of the technical advisory group chairs and other, and the council chair presides over that group. So with the chairs being appointed for those individual tags, This is the composition of that committee as it's standing today. And that is the end of this presentation. And so there's no need to take action here today if the desire is to hold until we get our seats filled out on the council.
Okay, thank you. I see a hand by Ken.
Yeah, just have a question. I know that we fought so hard to put together the correlation group. I don't know what to call it. Is it a tag? Is it a committee? But can we actually get that documented somewhere that you guys actually have a correlation committee or correlation tag?
Yes, I will add that to this group of committees here. It's not something that's included in our bylaws specifically as a named group. But we will get that out there and publish it along with everything else.
But we did take action.
It's been a couple weeks for sure on that one. And off the top of my head, I don't have the composition ready for a discussion here today.
Okay. But thank you, Ken, for raising it. Okay, is that the desire of the council then to not take action on this today until our council is all the appointments are made?
Yeah, motion to table
Okay.
until next meeting.
Is there a second?
Second.
Okay, we'll go with Katie then. So Chell and Katie have moved and seconded that we table this item. All those in favor signify by saying aye.
Aye.
Any opposed? Okay, this item is tabled. Thank you. Now we are on to the 2024 cycle.
And on this one, so as I get it opened up here, the published schedule as right now, why is this not popping open? Is pretty cumbersome to read. And so hearing the comments about it, I haven't had any specific requests to revise it. But as far as, you know, the way it looks, I've made an attempt here to do that. And I've brought in from 2024. So if we're looking at this, I've separated into specific codes instead of having it as group 1, group 2. We are also looking at here a 2-year timeline for the adoption process. It started in January of 2024 and is due by us by December of 2025. And so we've got easier to read, maybe a little bit longer document here. So running back up to the top, I want to get things presented out here in order of kind of how they're listed in our WACs. So up at the top here, we have the commercial energy code process. I don't have any modifications to this one here today. We have the residential group. And I guess as we go through this, we'll notice that there's a lot of work slotted here into 2025. And some of the challenges we're facing are having enough time for the tags to reasonably review reports on existing amendments, significant changes, review the proposals after a 60-day window, and then observing timeline requirements required by the Administrative Procedure Act, and also required by the Administrative Procedure Act and Regulatory Fairness Act are some reports that should go along with these code adoption processes that will inform on economic impact and small business impacts as well. And so right now we're in a position where if we experience more delays, we are going to find ourselves running up against a hard wall of not being able to comply with developing reports that stand up to scrutiny and de-risk our situation. for the cost benefit analysis and the small business economic impact statement. It's a large body of work that needs to happen. So the group 1 codes, all of those are still needing to have that economic analysis done. We are, as staff, strategizing how to have meetings for all the codes all at once with correlation groups, and also having time to draft these documents with, limited staff. I have gone before some folks and, in one meeting, a statement was made to me. It wasn't an SBCC meeting, but that relying on the statement that we don't have the staff to do stuff in the timeframes that we are trying to get them done is not a valid, reason to maybe not succeed in some of the timelines that we have established, both for individual meetings, publishing documents and things like that, but also in this whole time frame. And, reflecting on that, folks who might have the option to not do the work are able to not necessarily take on the work if they don't have the staff to do it. Right now, SBCC has statutory mandates to complete things within certain timeframes, and we have a limited budget and we have limited staff. And even if we had, more money for staff, it has been very hard to bring in staff that will fill the role adequately. I am very happy to have Brandon Grote on our team. He has embraced the Uniform Plumbing Code process spectacularly, in my opinion. And he's, taking on the body of work, and, we've got a lot to do to get that code. But like right now, the residential code is suffering lack of motion because I don't have folks that can really take on that role to alleviate the burden to keep everything else going for us. So right now, I've been wearing the hat of the managing director and a code specialist, trying to develop reports and get them out there. And the process is hard for me to get it going on. And it's overloading me personally. But that being said, I'm committed to keeping this process going and hitting our deadlines that we're trying to get. And I guess going forward, our IABC group is still lacking some economic input here. Our IRC group, I need to get reports finalized for this. They need to be reviewed by potentially the TAG. There's no statutory requirement to have those reviews done by the TAG. And I'm sorry, Tom, go ahead and speak here.
Yeah, I don't mean to interrupt here, but we've kind of talked a little bit about the staffing thing. With you in particular, do you have the ability in the budget or whatever to maybe hire, a consultant or a temporary staff member or something like that who might be out in the trades that can do some moonlighting or something like that that's well versed in these codes? Do you have a budget for that or the ability to do it technically in your department there?
Right now, there is some room in the budget for stuff like that. There's not a ton of room in the budget for that. So we do have an expenditure authority assigned by the legislature, and we don't have a ton of that left at the moment. As far as specific numbers, I'm not prepared to comment on that today. When we look at potentially bringing in staff on not permanently funded positions, we don't get a lot of interest in the permanently funded positions, much less something that's not permanently funded. And so, we're really struggling on that front. There is some room, you know, I've got, some, processes engaged here within the Department of Enterprise Services to analyze the SBCC budget and what there might be room for. We're triaging what we've got going on here and really strategizing a way to get the resources that we need. And so as we move forward, trying to get the work done, I do hope to be able to bring some sort of outside resource. One of the resources I was hoping to bring towards this particular code cycle is an additional third-party economic analysis for all of our codes, not just the energy codes. At the end of our 2021 cycle, we suffered some scrutiny on those reports for APA compliance. And while we prevailed in the legal challenge there, you know, I've engaged with some of the folks bringing that scrutiny, and they're not asking for perfection this code cycle. They're just asking for better. The gold standard I would see as being, you know, that unbiased third party doing some of this work for us so we can write the reports. But we, as far as the contracts, getting those in place, we are in a position where the timelines aren't going to meet up for us. So we're starting, we've got that process started. There's been hiring and spending freezes put on state agencies by the governor. We do have exemptions in place for those. But the process to bring those resources to bear is not exactly expeditious. And so the movement that we're having to go through right now is to engage the work group of economic impact, essentially as the sole source for the input on these reports. We have in the past relied heavily on the information provided by proponents in proposals. We've received criticism on accepting proposals as complete. So as we go through, you know, planning the rest of this code cycle, looking at other code proposal windows, I'm working with staff to try to bring a clear criterion for them to accept and reject proposals. You know, and the economic impact, you know, if someone says, no, there's no economic impact, and the sniff test fails, that there is actually economic impact, you know, that's, you know, there's no real ration, we don't have great SOPs in place to inform the staff actions on that type of activity. And so without a lot of the process within staff being well defined, we are not in a good position to, on a whim, reject proposals. And so we're trying to make moves to really prime the 2027 code cycle so that it is well thought out, is planned in a timeline that is tenable by the volunteers and by the staffing that we have, and you know, try to move forward.
Okay, yeah, I was just wondering, you know, I mean, there's a lot of, you know, experts among us that may have time, you know, maybe not, you know, there's certainly some people here that know the code inside and out, and, you know, could be, you know, take up some of that code specialist slack, perhaps, you know, just depending on, I don't know, if you get the word out, maybe there'll be somebody that steps up that can do it. You know, just part-time and get you through it. So.
Gotcha. I appreciate it. Angela.
Yeah, I was just curious, because I'm the IRC chairperson. On this schedule, it says that the IRC reports are supposed to be, I guess we're supposed to be reviewing them the 21st through the 2nd, and it's the 25th. And so, I mean, one, I guess this needs to be updated because I don't believe I received those reports yet.
I have not.
Okay, and then two, you had mentioned that it's not actually a requirement that the tag review those or do whatever. But if that doesn't happen, then what does?
Well, I mean, as we look forward to what is possible here, the status of those reports, I have a existing amendment report, done essentially. There's some components that I would have loved to included in there that are not included in there. Primarily being the, rationale, on the history and creation of those amendments. You know, as we have, in my experience so far with SBCC, the question on why do we have this amendment arises frequently. And so doing the research back through the RCWs and filings that we have, sorry, not the RCWs, but the WAC history and the filings that we have and the rationale statements included by SBCC in the past, doesn't necessarily inform great rationale on why the amendments exist there. So as far as including that rationale in there, most of that's not there. But as we're looking at the significant changes report, I have essentially, I don't know, I would say somewhere in the realm of, 30 to 40% done on that. And it's proving to be challenging to get those done. So, that the IRC group, the IRC work is something that I was hoping to address here as part of this discussion today. I fully realize that the dates that are on this document are, already out of alignment with where we're at. And so, strategizing a way to go forward with this, looking at what's in our WAC 5104 for the process. It says the committees shall approve reports to the council with any recommendations for amendments. But, watching what's going on with the other tags and how those reports and integrated drafts are being reviewed and content created in there. If this doesn't go to the tag, then it essentially, in my opinion, feel like it falls to me to make a recommendation on whether a amendment is required, and then for the committee to then affirm or deny that recommendation. And then the tag work could begin after that. Do I like that proposition? No, I don't like that proposition. I would love for the tags to be able to engage and discuss these reports. Within the UPC group, they did a heavy lift with many hours in a meeting and got those reports most of the way across the line in about 2 weeks, but there were some large or long meetings required to do that. Looking at the remainder of the schedule, there is a lot of work that goes into the drafting of the CR documents that get filed with the code revisor. There's a lot of work that goes into the reports at the end, and there's, our requirement for a 60-day submittal window. And then, as we get into here, if we're looking at the review of the amendment petitions, there's going to be probably a few amendments that come through to the IRC, and it's going to take more than a week or two to do that. So I've got 2 months put in there, and not a lot of time for staff to draft the CR 102. I've got a minimum time frame for a comment period, and then when it comes down to drafting any of these documents, there's a lot of work that has to happen. And if you'll notice, that line is from September 5th to September 17th. We're in a position where I don't think that we can meet the statutory requirements to bring, I guess specifically at this point, the IRC across the finish line in December. But I'm unsure how to relieve the pressure at this point.
So did you say though you have one of the reports that's ready that could kind of start being looked at? That's the existing amendments without
Yes, we can begin work on that if that is what's desired. You know, as we've reviewed them in the past, the existing amendments and significant changes reports do kind of go hand in hand. So yeah, components of the existing amendments report do bring in the changes in the model code to those specific sections. And then there's, you know, reference to separate report to the, you know, to each report. There's references back to those reports within these reports. And, you know, so the reasoning that I haven't initiated review on those yet is because I feel like they go hand in hand. But in the interest of making movement, we can start reviewing the existing amendments reports as soon as next week, but we would need to notice those ASAP.
Can I just get a copy of that report that's ready? I mean, part of my issue is I'm at the ICC hearings for the next week and a half. I leave tomorrow, and the actual international code hearings are now happening. But if I can get a look at it just so that I can get my head wrapped around it so that I can kind of get a game plan together, that would be really helpful.
I can definitely give that to you.
Thanks.
Go ahead, Roger.
Dustin, I was remembering for the IBC that the tag was involved in the review of the significant changes in the existing amendments. Is that not happening for the IRC? And could it, I guess?
So yes and no. So your recollection is correct. For the group 1 codes for both IBC and IFC, the reports were not ready for that group to start digesting, similar to right now. So the ask that was made of the group was to essentially help staff write those reports. So the reports were chopped up, disseminated out to the individual tag members, and there was a lot of extra work for staff to bring all that back together and you know, make the report a cohesive document that could be read. So one of the big challenges that we face is not necessarily identifying where the changes are or where the existing amendments are, but characterizing how those changes are and formatting changes that happened as a result of having multiple people draft the report. So folks involved in the UPC right now, they had the benefit of having a report that was pretty much fully drafted, and they had to give an opinion on the content of what was recommended by staff at that point. And there wasn't a lot of draft work required by those individuals. And I believe that that enabled them to actually go through the report in a much more expedient manner. And so that was the pivot that I was trying to make for the group 2 codes, and suffering from, you know, time issues. I haven't had the opportunity to get the IRC report across that line. And similarly with the WUI code, if, you know, we decided to do that, developing those reports, you know, it's a small document, it shouldn't be as hard, but it's an additional task for staff to undertake at the moment. And so I was hoping to bring some time savings on the staff recombination of that input from the tags. I am extremely grateful for the tag work that was done on the group 1 codes, you know, taking those documents and, you know, kind of templates that we put out there for folks to do the work. It worked great, but we had a lot of time used to put those out, have folks work on it, and then bring it back and compile it and then review it. It did come back with tag member recommendations, which made that a little easier. But the hope is to say we have this whole report and bring it down and be able to, cruise through it without having to necessarily fiddle with formatting, for lack of a more graceful term.
Katie, please.
Hi, thanks. Thanks for this. It is a lot easier to read and understand here. And just for the record, I want to put on the record that I think it's ridiculous that somebody would say that not having enough time is no excuse. You're and the staff of the SBC and us are only human beings. We all are dealing with so much. So to Larry's point, the answer isn't more volunteer work. The answer isn't, clearly it's a difficult situation and I don't have answers, but I disagree with whoever said that a lot. So thank you for your hard work. The whole staff of the SBC, you guys kill yourselves and you shouldn't have to. So, but thank you for this schedule. And I don't know if we're looking to try to amend it or if we are just going to accept it. But
well,
that's all I want to say.
Thank you.
The one thing I was hoping to come out of this discussion was an attempt to address the IRC timeline, which would be an opening of a proposal window similar to what was done for the Group 1 codes, with a difference being that we don't open it for 90 days. I know that the reports being out there inform on proponents who draft proposals for code change. But the reality being that we don't receive the proposals until the end of that proposal window. So as we get these out there, it's a kind of sit and wait until the onslaught comes. The proposals then come and we have to vet them in a short amount of time, and then potentially after the proposal window closes, still work with proponents to get these proposals across the finish line. If we request some additional information, they're not automatically rejected. We have a process in place to allow for amendments to come through. And, so if we could open up a proposal window for the IRC, we can make up a little bit of ground. I don't know if it's going to be the fix that gets us across the ultimate finish line of December 1, but it is one component of a strategy to help us meet that statutory deadline. The other component of the thoughts that I've been having and discussing are, we have our regularly scheduled meetings. That's in an effort to plan what's going on. But in order to meet some of the minimum timeframes that we're now facing, special meetings are gonna have to start occurring to get things across the finish line.
Okay, we're gonna take a couple public comments here and then we'll try to move towards a actionable item here. Let's go to Patrick and then Ken.
Yes, thank you. Patrick Hanks, Building Industry Association of Washington. Obviously, the residential codes are of the most importance to our members. That's the bread and butter of what we're dealing with. So what happens with that is very important to them. And I'm looking at the schedule here in addition to what Dustin's brought up about the IRC running behind schedule. I'm looking at the schedule for the residential energy code for 2024, and it looks like we only have 3 weeks scheduled for the tag to go through all of the amendments that will come in. And I know that the commercial energy code tag has taken a lot longer than that and still hasn't gone through all of their amendments. So I'm assuming that it's going to take a similar timeline. So I think hearing that you have staffing shortages, but you also have difficulties filling that and then getting contracting done to try to fill up the work. I think at some point it's helpful to have an honest conversation about whether or not realistically the residential stuff can get done this year, or if you need to start planning on deferring that and then set a more realistic timeline that gives you built-in time for, you know, the tag to do their work, for the staff to review petitions after they come in, so that instead of constantly giving yourself a very short stick and not a lot of room, that we have a realistic timeline that can be done. And then we're not trying to crunch and everything, and then we have a good expectation as stakeholders, knowing a solid plan of what's going to happen and when things are going to happen. Thank you.
Okay, thank you, Ken.
Okay, again, Ken Brulette speaking on behalf of the code specialist or the alternate on the IRC tag, not as a Seattle Fire Department representative. I have put in probably over 100 different petitions or code changes over the last few years. And I understand the importance of having the existing amendments and significant changes reports. But most of us that do put code change request in, we already know the history. We already know the significant changes because we've done the work in developing our code changes to make sure that they mean something and they're not going to be in contradiction to anything. So my recommendation is yes, that's, you have majority of the work done on the existing amendments, some of it on significant. We can work as a tag as an alternate. It makes it nice for me because I could actually help out a little bit with that during those meetings if necessary, and help fill some of that staff role that you don't have as an SBCC, because personally I have to take off time from my regular job to work on that IRC tag. So I'll actually be an unpaid person for you doing that work. And I think that you need to open up that submission, the petitions period, and get that going so people can start submitting them, getting them going. And again, the people that are going to submit them, they don't need those reports to actually do their submission. It's helpful, yes, but it's not a requirement. The last thing is that with these dates that have been published, the people that are, volunteer their time for the tag are expecting those, timeframes to be when their time commitment's going to be needed, and to keep pushing it down and changing it could affect what they might have had planned personally for vacations or other time commitments because they've seen these dates published. So that's my 2 cents. Thank you very much.
It's helpful, Ken. Thank you. Let's go to Roger.
I have a comment and then I would like to make a motion. The comment is I really appreciate the condensed schedule, although I'm not sure. I question whether that, I know that was requested by members of, I don't know if it was council and or public at the last meeting, but just regurgitating information in a different way doesn't seem prudent given that we're short of staff. So I think most of this information was already included in the previous version that I know was really long and hard to read, but it was there. I didn't see in this updated version the single exit schedule. And again, as far as I'm concerned, you don't have to redo that schedule. It's out there, it's published in the longer version. And that's all we need in my opinion. Todd, I guess I would like to make a motion about the IRC, and that is to open up the proposal window today and make that a 60-day window rather than a 90-day window to get this process started. As Ken said, I think people that are so that's the motion. Speaking to the motion, I think people that are involved in the real changes are aware they don't need the report. I agree that it makes a lot of sense, and that's a great way to start the process and start naming proposals and that type of thing. But I also think that 60 days, if we get that report done relatively soon, we still would have potentially like 30 days for the whole public to be able to use that version. So I think to open up the proposal window today and have it open for 60 days, which if I'm not mistaken, that's June 23rd, wasn't that we did what we did recently, previous in this meeting. So that's my motion.
Okay, let's entertain a second, but also hear from Angela as chair.
Oh, sorry. Yes, I was actually going to say that, yeah, because I agree with Ken that most of the time, I mean, people, when you're doing proposals, as far as the existing amendments, you're looking at the Washington State Code when you're looking to amend the Washington State Code. And if you're doing a good job at writing proposals, you should be actually referring to the base code also to make sure that you're being accurate. So I don't think that a little bit of overlap before we get those other reports would hurt. I think it's a good idea.
Okay. Angela, you want to weigh in on the 60 days, or is that a second?
So the 60-day, yeah, that is a second.
Okay. Thank you. Okay, we'll take a comment from Patrick.
I strongly disagree with this. You have an active window right now for the residential energy code. You just opened an active window for the UPC, which can affect residential. And then there's no reports, which I guess maybe some other people don't rely on that. I heavily rely on knowing what the tag is proposing to change, specifically like what amendments they're going to make, what the significant changes are, and having an idea, and then using those. And I just had a co-town hall with our members early this month on going over those reports for the energy tag and getting their input on it. And we specifically discussed items from those reports and using that in our code development process. So you already have an active residential window. You would just open up another, and then you're adding a third with a 60-day window for reports that don't exist. That's a massive amount of workload and expectation on a single stakeholder group to meet that. So I strongly disagree with that.
And just to be clear, and I think I'll throw it to Shell here, the integrated draft and the energy side is different than what we're doing here, but go ahead, Shell, and I'll get to Larry.
I was going to respond that we have a group 1 codes and group 2 codes. And so the structure of the way the council works is we often have many code proposal windows open simultaneously, i.e. we have group 1 codes open at the same time and we have group 2 codes open at the same time. There's slight difference here, but we're structurally set up to have lots of windows open at the same time.
Larry, go ahead first. I'll make a comment.
Yeah, I'd sure like the 90 days. I mean, the construction business right now is just really jamming hard. Okay, because we've been through winter. The dirt's just getting ready. We can dig and get going. And I mean, I'm working 7 days a week right now, just trying to keep up with it. And I've got other reports that I need to get back to Shell already. And now you've just narrowed the window down another 30 days. And we're trying to run businesses, the stakeholders are, and we're trying to also re-review what's going out. And it puts a huge burden on the stakeholders and probably you people too, to narrow that down to 30 days. It'd be much better to extend the time period somewhat than to put this burden upon all the stakeholders out here when we're in the middle of, we're just getting our construction businesses slated going, getting them in going. And then we're having refrigerant changes right now. We're in the middle of a refrigerant change. So the people are going through training, and it's a nightmare right now. Thanks.
Thank you, Larry. Could we get someone to remind the council on a requirement to, before the council submits the petitions to the tag, why we can't have overlap? I'm forgetting.
So you're asking why we need, is there anything in our bylaws or statutes that requires us to do the reports first before we?
No, sorry. Why do we have to wait for the petition window to close before the council can start moving? Yes, go ahead.
But if I can respond to that, I think
Yeah.
that I think that has been standard operating procedure, but I don't believe that it is required. Other than potentially the tag can't take official action on proposals until after they have officially been referred. So if we were getting proposals, the tag, in my opinion, and my understanding, the tag could start deliberating and potentially making initial decisions on proposals, but we would have to wait until the council has officially accepted all of the proposals and then made a vote to push those proposals down to the tag like we did for the plumbing code today before official voting can occur.
Okay. I'm seeing hands from, thank you, Roger. Angela first.
Yeah, I thought we did under the first group, or was it group one, that they did do that they were getting an early look basically at proposals so that there could be tag meetings, the public, the members, whoever, they could have discussions and things before the official review period started, so that they could get some of that legwork out of the way. But again, yeah, the official posted is when they can take official action. And I think the reason you don't want those two to officially overlap is because new things can always come in until the last day of that submission period. So the council or the committee could have approved something in that overlap period, and then something else comes in, and now you have to do backtrack, compares it, something like that. So I think that's why you need to know that you have all of your information before you start officially making moves on it and voting.
Yeah, agreed. Okay. Jay?
Question on the amendment we're considering. I'm looking at what was posted in our packet and then looking at the previous schedule from our meeting last week. Originally, the group 2 codes had a proposal window open from 4/18, which would have been our meeting if we could have had it last week, to 6/16. What's being proposed today is opening it today for a similar 60 days. Just want to clarify, because if so, that does not look like a major change compared to Patrick's comment from what was plan of record previously.
Okay, that was my motion, opening it today and opening it for 60 days, which I think is June 23rd.
And so that's just reflecting the change in the official meeting 1 week. And other than that, when I look at the schedule we talked about in March, it's not shortening the window at all. We're just shifting it. And because it was 60 days in looking at the schedule that we looked at our March meeting.
Yeah. I think that's right. Go ahead, Angela.
Yes, sorry. I don't think the 60 days is the issue that people are, I mean, they are kind of, but it's also that it's overlapping before the reports come out is a difference that is changing.
I understand. And I think there's probably a couple of different classes of code changes. One is, as you had mentioned, Angela, before, code changes based on the current custom Washington code. And then there's also going to be code changes that may be proposed once you see the reports, and wanting to make sure, as long as that there is some time to be able to respond to the reports, I think we're okay. Thank you.
Okay, so I think one of the things we're discussing here is that if we open this window right now, the date's certain. If it's in 60 days, that we don't have a council meeting. That's a week past our council meeting, perhaps, but we can address that, so we can move it down to the tag. but the TAG could begin reviewing those. Okay, Ken, go ahead, and then we have 12 minutes, or yes, we have 12 minutes
Yeah,
left.
just quickly, I don't know if it compromises, can you open it up now, but open it for 90 days?
You know, I think 90 days was did we do that in the group one? I can't remember now. Or did we move it to 60 days?
We did it for 90 days, with the, reports coming out. And then after the reports were out, there was 60 days after the reports for folks to submit proposals.
And we are required for only 30, is that correct?
Only 60.
60 is the minimum requirement. Okay.
Yes.
Thank you. I'll leave it to the council. I mean, the motion on the table is for 60 days starting today. Okay, there's no other discussion. Let's take a voice vote. It's been moved and seconded to begin April 25th for 60 days. All those in favor signify by saying aye.
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 Any opposed? Okay, the IRC window is open. Let's keep moving because we have 12 minutes left. This is our last agenda item, but I think, Roger, you want to talk about, let's just lay out what we need to talk about. Single stair, single exit, and is that it? Because we opened the UPC already?
Yes.
Okay, go ahead, Roger.
So single exit multifamily and multiplex housing tag is up and running, and we are starting to have conversations about some proposals. The window is currently opened and scheduled to, dang, no, I don't have it up in front of me. Scheduled to close on May 19th. Our May council meeting is May 16th, the Friday before that. What I would ask the council to approve is to modify the opening date rather than being from May to May 19th, to make it May 9th. So basically, we're closing that window 10 days ahead of time, earlier than what has been posted currently. So that at the May council meeting, we can officially get all of those proposals and send them to the tag so we can really dig in and start to do our work. I know that there is a question about the comment that we just had about 60 days. However, the single exit multiplex housing tag is legislated, is required by the legislature. So we do have some leeway in our processes as far as how we move forward. So I think that what I would ask the council, and I can put this in a motion if we want, but would be to modify the window for proposals for the single exit multiplex housing from closing on May 19th to closing on May 9th.
Okay. Thank you, Roger. Angela?
Yes, I would ask, is that something that we can do once that's been published and opened and people are maybe counting on that as far as the work that they're doing or things like that? That's what, taking it, you want to do it to the 9th, so it's a week and a half off of the time. I know that there are major proposals in and things like that. I also know that there are kind of problems and disagreements with the major proposals that are in. So I understand why. I'm just not sure, if that's a thing. So yeah, sorry.
And Roger, I'm going to throw it to you, and I'm going to maybe ask the question, is it necessary for the council to move these petitions to since it's already, the committee's already directed to address this, but go ahead.
I was going to say that there are a couple of major proposals in already, and I've talked with some other folks that I'm aware of that are contemplating other proposals. I do think this is a little bit different in that we are directed to modify the IRC. And so, you know, the exact code language, the proposals that we get already are pretty significant changes to the IRC. And there is going to take a fair amount of work for us to get through that and correlate actually with the IRC tag probably at the end of the day. So my goal is just to get started. I think that my understanding is most of the players are already working towards getting their proposals in. And in fact, this was discussed at our last tag meeting. And I realize that it is getting close to the time where I'd hoped to have this conversation last week, but we didn't have our meeting last week. So,
But Roger, I think again, I asked the question, your motion would be based off of the assumption that the council has to take some action for the committee to consider those. I would maybe argue the committee already has the authority to consider those. What do you think about that? When would that, and would that change it? I hadn't thought that until just now, so I mean,
yeah,
I'm saying that
no,
over.
No, if that's appropriate and we can get started, I believe that our next meeting is May 19th.
I think it's May 9th. Is that
May 9th?
Am I maybe wrong on that?
My schedule's all messed up,
Okay.
so,
On the 16th for the council meeting.
yeah,
Council meeting is the
What about
BRFW
the-
meetings on the 9th.
the tag meeting
I'm sorry, the tag meeting.
was May 5th and then May 19th, and the May 5th, I believe both, I will be out of town and the alternate chair will be out of town as well on May 5th. So it was talked about skipping the 5th meeting and then starting on the 19th.
Got it.
So, I'll leave it open. I mean, again, it's kind of similar. If we have a meeting on the morning of the 19th, then we could still be getting proposals that afternoon. But we can start our work and perhaps, given the fact that we are legislative, we are mandated by legislature, that we can not have to go through the official process of going through the council and sending them to the tag.
Joe.
Yeah, I guess I want to ask the question, is it even legal to change a window once it's opened with a published date? I know some people have asked me questions about this particular code window, and I've emailed them that it's May 19th. And I'd have to go back through all my emails and email all those people and say it changed if it changed. I'd be surprised if it's legal to do that. And I'm kind of asking the question of Dirk.
Thanks for the question, Shell. What would be, so if I'm tracking this, well, sorry, I always feel like I'm a step behind because you guys are having such a robust discussion, and I'm wondering from you, Chell, what would be the legal basis for thinking that it's not appropriate?
Well, if you say I can accept proposals from one date to another date, and then halfway through the process you change the final date, people have already scheduled,
Oh,
it's
I
already
see what you're saying.
communicated, and people have made plans on it, it seems like it would disenfranchise some people from their ability to submit proposals if they were working to last minute, which is what most people do.
Yeah. So, well, let me just say this. I don't think I would be prepared to opine on the legality of that. And if I did, I'd want to be careful about how I did. So I would say that, you raise obviously some good policy arguments that would sort of militate against changing it. But I guess I would say off the top of my head, this is me pausing and spitballing a little bit. I can't think of any specific legal concerns with it, but yeah, there's always risk that people could identify some legal considerations here. That's the best I can do.
Okay, yeah, I guess I'd rather suggest that the tag pre-consider things as you've already done, Roger. than change the date, because it just seems like, I don't know. Seems like once you publish a final date of something, it just seems like it's challenging to change it.
I appreciate Shell's comment, and I actually am, changing my mind. I think that the committee, the tag can deal with it if we get proposals after. And in fact, thinking about it, the whole conversation we've had about the December 1st deadline, I believe that because we are, because our work is mandated by the legislature, I don't believe that we are held to the December 1st deadline either. So, and I would need to dig into that and make sure that legally I'm correct in that. But so I'm fine just withdrawing the comment or the request, and we leave the date open until the 19th.
Okay. And I think we've made it very clear here that we intend to begin on the 19th and at that meeting.
Yeah.
Okay. Okay. Thank you. Okay, we are at 2 o'clock. Is there anything else on this, or are we? I did doom us. We went straight to the end. Okay, with that, we will close agenda. Go ahead.
Well, you do have a petition, right, that you need to address?
Petition.
I move to extend the meeting 5 minutes.
Thank you.
10.
I'll second your motion.
Okay, was that 10 minutes at the end there, Tom, just in case?
Probably, yeah.
Okay. All those in favor of extending for 10 minutes signify by saying aye.
Aye.
Any opposed? Okay, we're extended. Roger, I'm sorry, I'm blanking. Remind me, please, on the petition.
All right, well, this is just an email from Dustin.
If it's the petition, we received a petition earlier this week. And in order to meet the guidelines to get that one done in time, so we have the new rule for the council. We cannot take action on a petition at the meeting where it's introduced. Because this meeting was adjourned from last Friday, I did not add that petition to this agenda. And so we'll be introducing the petition. It's a one from the Washington State Association of Fire Marshals, and it addresses building setbacks and access to the rear of lots and things like that. And so the plan is to introduce it at the May regular scheduled meeting, and then to meet the 60-day turnover time maximum on that one, we have to take action on it at our June regular scheduled meeting. That is the deadline is that day.
And that clock starts on when we introduce it, or when it was received?
Starts upon receipt of the petition.
This week.
Yeah, and so
Okay.
once I got that one, based on the date of the submission on the request is when started that time clock.
Okay. Okay, thank you.
And Todd, I want to, since I failed so utterly at answering Chel's questions, I want a second bite at the apple on that, and also to irritate everybody by taking another minute or two before we wrap up. First of all, I just wanted to note in response to your question, Chel, that our APA always creates a cause of action for agency to challenge agency action by members of the public, alleging that if the basis, I'll try again. I thought I was ready to go, and I'm not. There's a cause of action under the APA to challenge agency action if it's arbitrary and capricious, and so we always work hard on the council to make sure that we have well-reasoned and supported decision making. So theoretically, Chel, if an agency were to just shoot from the hip and change something without having gone through any reasoned discourse to come to that conclusion, there could be a question of the legality. Okay, so I just wanted to close that point. And also I wanted to circle back to Roger. Roger, and just to prove that I was paying attention to you too, in my opinion, the December 1st deadline for adopting codes applies to codes on the triennial adoption schedule, which yours doesn't. Although, of course, it does have to be adopted in time for the 2024 code to go into effect. And so I don't see a December 1st deadline looming for that specific work that the TAG is working on.
And Derek, just to be clear, what you're saying is the implementation date of November 1st, 2026.
This is
not the December 1st adoption on the triennial cycle.
correct.
Okay.
Yeah. So Roger's question was whether the work that he's in the TAG are working on right now on this, I'll call it legislative one-off change to the code, has to be adopted. Any statewide amendments have to be adopted by December 1st. And in my view, it doesn't.
But if I remember the statute on those two bills, it did say with the 2024 codes
Correct.
for implementation by November, implying November 1st, 2026 as stated.
Yeah, I actually think one says implementation by November and one says approval by July.
Yeah.
Something like that. So
you're right. It didn't get
attempt
updated.
is to get that included in the 2024 IRC.
But we're also getting code books printed up, and there's a schedule for that as well.
Yeah.
Right. We're not waiting the last minute. We want to be done by July anyway, but
It was our intent to make the December 1st deadline, but given that, but we do have extra time if needed. So.
Yeah, I think we're going to get there. So, okay, Angela.
So then, because this was a legislative body of work or whatever, it doesn't have to sit through a legislative session like the rest of the code does. Is that correct?
I think that's what we're saying, Derek, right?
Okay.
Yeah.
The requirement that the codes under 1927 have to be adopted by December 1st is for codes that are on the 3-year adoption cycle.
All right.
How's that, Todd? Did I succeed at the end?
I think we're exhausted. We covered a lot of ground today.
Yes, you did.
Okay. Any other business? If not, thank you, everyone. We are adjourned.
Thanks, everyone.
Thank you.
Everybody.